Lordship, this matter regarding Shiksha Cycle, let it come. Lordship.
21st is very auspicious day for you.
No, Lordship, the second matter is also 22nd, because one day I'll.
20. It's a very urgent matter out of this time. There's the admission matter in Orissa University and Agriculture Technology. I got selected. I have a rank card. I was present at the time of selection, but my name they did call and they said that seat is filled.
Yeah.
Revision of grade pay, revision of grade pay as per with the colleague of the petitioner.
Already similar matters are admitted.
This is for final hearing. Counter agenda 2024. The second order of litigation. Second order of litigation.
This is the academic matter, my lord. The petitioner father's name is spelling mistake in the certificate, my lord, due to mistake tomorrow.
Tomorrow.
May I finally, my lord? Widow daughter is suffering miserably for the last 5 years.
5 years.
Matter is up to 24.
It is out of my lord.
It is a review matter filed by the government against the order of the FAO out of the education, my lord, under the Education Act. Your lordship may call it, my lord, on 21st, my lord.
We can't expect it now.
Your lordship coming, my lord, taking up all the FAO and connected matter, my lord, on 21st. That's why I'm praying.
My lord, rehabilitation appointment.
Another phase matter, my lord. Another phase admission, your lordship may take up any day, my lord.
Next. Appointment to the petitioner as the regular teacher billers. TGT scale. 2024 matter.
24 matter in 2 weeks.
Your lordship. Finally taken up to heart patient billers 25 units.
25.
Matter relating to release of pension. Release of pension and pensionary benefit.
My lord, matter regarding rehabilitation appointment.
Rehabilitation appointment which year?
2023, my lord. The second round of litigation, 23.
Your lordship, this is a case where petitioner is seeking direction to the Tehsildar Barang for correction of legal year certificate.
Legal year certificate?
Yes, your lordship.
Your lordship, this is the retired teacher. After retirement, the opposite point number 2 revise the grade pay of the petitioner.
Retirement, revise it.
Revise of the grade pay of petitioner. Yes, my lord.
2 weeks.
Fresh admission.
Fresh admission. Next week.
Lordship,
Pardon me. Instead of 21, 22, my lord. 21 I'm not available. 22 prefer.
Which matter? How can
The academic matter, my lord.
write down? Give that. Write that date. Do you remember that?
Yes, sir.
Lordship, the petition, the urgency, the petitioner challenged the order of the Secretary BDA and
Which year?
So 2022, your lordship.
23.
22.
22.
Yes.
After 2 weeks, can we have that? Yes.
And pattern mention, my lord. The petitioner and also planning for
Which year, man?
2024.
24.
My lord.
2 weeks.
Big intervention, my lord. My lord, on being mentioned yesterday, your lordship, considering the urgency of the case, took up the matter and passed the order. But sorry to say that the order has not been uploaded.
But if I give that number, why not something? Just okay to upload it immediately. Now see, they are saying, go and see. Go and see.
Just 10 minutes back, it has not been uploaded.
Is it?
My lord.
Yes.
10 minutes back.
Upload it immediately. Any adjournments? Only one matter.
58, the contesting party, the impugn order of the authority, which I am challenging in the writ application, has filed the counter affidavit and served me the copy yesterday evening.
You want after 3 weeks? That's the request of early considering for the petition.
The Lordship, the entry border may kindly be
Interim order, then 4 weeks. 4 weeks. Yeah.
Item 69.
Ah,
Item 69, government has not filed counter, my.
69.
Yes, ma'am.
Ah,
Next week.
3 weeks. Same order. No interim order is there.
No, ma'am.
Yeah, problem.
Item number 11.
One, my lord, I beg apology with apology. I am submitting, my lord. On 12th of August, your lordship directed me to get instruction. If the order is not complied, then cost will be imposed. In fact, my lord, it is a fact that this matter is covered by the case of Sarath Parida and Hemant Chotrai's case. The case is in the session of hearing before the division bench of this honorable court. So normally your lordship is directing to get these matters listed in the 3rd week of September. Unless, my lord, it is settled, my lord, how can we implement the order passed by your lordships?
Will they stay in the appeal?
Not yet. It is in the,
No,
my lord, it is in the session of hearing. I'm sorry.
at the stage of hearing.
It was hard for 3 to 4 times.
It has been pushed. It has been ported to 15th of September.
15th of September.
Yes.
September. That matter has been ported.
But should I call this matter thereafter so that
This court, by order date 12/8/2025, had said as next matter. Learned he appearing for the opponents, OPs, submits that the question involved in this matter is being debated on the floor of division bench of this court. And therefore, some concession be shown by calling this matter in the last week of September. First time. We'll call it after September because division bench matter will be published. Next, there is no very fairly it is with this proposal. First time. Next paragraph. In the above circumstances, call this matter. In the last week of September is holidays.
last
From 26th,
27th. In the
27th onwards.
In the 3rd week of September, we'll say that.
3rd week,
In the 3rd week of September. Oh. Yes.
Item 2. Matter of regulation of domestic accommodation. Identical matter lordship has directed.
Issue emergent notice. See that order, same.
2/5/15 identical. 2/5/15.
Have you written that?
And this today list.
Today's list.
2, 5 and 15.
2, 5
and 15.
and 15.
15, 1, 5.
1, 5. All.
2, 5 and 1.
All.
And identical.
All along with him. Yes.
Item 3. But item 3.
That the petitioner is with ST category seeking promotion.
Your mics nearby. Or you can stand in between.
But the petitioner is seeking a direction that at least let them follow the rule 26, which prescribed that reservation principle is strictly required to be followed in case of promotion. And what they have done, my lord, under annexure, my lord, 4, they have enlisted 1,073 candidates of UR category only by only taking 9 candidates SC and 2 candidates from ST. Here, the present ST.
You will represent.
Just the similar matter at the instance of your category had come before this honorable court, and this honorable court, while directed not to give effect that list because it was no gradation list was finally published, also directed to publish a fresh gradation list. My responsible submission is only small relief is required. Let them
Preparing the fresh gradation list.
Yes, that is the order. You lordship kind of glance. My brother would have been aware of. But my humble submission before lordship is, since the petitioner belongs to the ST category, in terms of Rule 10 of the Reservation Rule of 1976, read with Rule 26 6 of the subordinate basis promotion rule, the separate gradation list for SC/ST is required to be prepared and their promotion according to roster is to be made. Only this observation will suffice the issue, matter can be disposed of.
My lord, as per rules, your lordship say what, why indicating?
6 that I have quoted, my lord. That I have quoted. It is quoted.
This is a case, my lord, where Madam said,
Now, fresh selection list is being, gradation list is being prepared.
yes,
Is it not?
yes.
Now he has made your representation. Where is your representation?
Well, my representation is sure, 5, my lord. What I pray, my lord, if your lordship will,
You're asking a
but
question.
batch of cases, your lordship will, if you observe that only 26 rule is required to be complied.
That I'm asking a question to you.
My lord.
It is simple. Constitution to be obeyed.
My lord.
Yes, everybody knows that. But how many articles in the Constitution? What is meant by obeying?
My lord.
Therefore, did you give a representation saying that? See, now you have an opportunity to make a fresh gradation list. Therefore, consider my grievance. You have to make appointment. You have to earmark certain posts for SC/STs.
Yes, ma'am.
In terms of prescription under Rule 26.
Yes, ma'am.
That's all.
Yes, ma'am. Your lordship representation that will be considered within the
Petitioner, how many petitioners?
but here the one petition.
Petitioner, you are an aspirant for
Getting
promotion.
Yes, my lord, because I possess the qualification and the moment it will be included, my name will be included in the gradation list, then I am entitled to, because around 400 above ST vacancies are there.
Total vacancy, how many?
My lord, it was of the year 22, it was 1073, but now by this end of 25, it is more than 2000. It would be more than 2000.
Petitioner has scripted his prayer in the petition as a next paragraph. Learned counsel for the petitioner submits that the recruitment year in question, that is 2022, had 1,073 vacancies.
My lord.
And that
Promotion, my lord, not recruitment, it is promotion.
that is considered for the purpose of appointment by promotion.
My lord.
And now that number has swelled. Semicolon. Rule 26 of
Orissa Subordinate Education Service Condition Rule.
how we should write.
My lord, that is, your lordship, I have enclosed, my lord. In my annexure, entire rule I have given, that annexure 3.
Take a pause. Next.
Orissa Subordinate Education Service Condition Rules.
When you are communicating,
My lord.
you should be aware of the status of the addressee. We are not Socrates here. We also come from rural background. Therefore, what you say, whether it reaches the mind of the judge, well, the other colleagues for us, they are not doctorates from Oxford University. They are from local colleges, etc. Therefore, whenever you speak, Jeremy Bentham says, speak small words so that small men will understand things. They are all small men only, maybe having big egos because we are sitting here. That's another thing. Okay? Therefore, be slow.
Let me read the nomenclature of the rule. The Odisha.
So you should be slow.
The Odisha.
26. What you written now? 26 provides for reservation in the matter of appointment by way of direct recruitment or by way of promotion. Anyhow, pursuant to a coordinate bench order dated 16/5/2025, entered in WP numbers 26759 and 30932 of 2024 between Prasanna Kumar Sahu and others versus State of Odisha and others, comma, a fresh gradation list is now being prepared, and therefore, if Rule 26 is implemented, no to anyone. First one. Next paragraph. Learned AGA appearing for the OPs opposes the petition, contending that ordinarily the prayer for writ of mandamus has to be preceded by a demand and rejection of the demand. Semicolon. That having not happened, petitioner is not justified in hastily knocking at the doors of writ court. First, having so, comma, in all fairness, now he submits that if the petitioner makes an appropriate representation, comma, there would be no difficulty in considering the same in accordance with law. First, with this proposal, counsel for the petitioner is also agreeable. First, next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make a representation coupled with the supporting documents to the jurisdictional authorities within 2 weeks. If one be made accordingly, comma, the concerned authorities shall duly consider the same while preparing the fresh gradation list of employees as already mentioned above. First, all contentions of the parties are kept open. Next paragraph. It is open to the jurisdictional authorities to solicit any information or documents from the side of petitioners or from the concerned departments for the purpose of due consideration of the representation in contemplation. First, no cost.
Yes, jurisdictional authority is OP number 2. Jurisdictional authority is opposite but not 2.
Jurisdictional authority. We don't know.
Item 4. Identical methodology were adjourned to second week of September.
Regularization. Issue emergent notice. Learned AGA on request accepts notice for the OPs. Call this matter along with WP number so and so. Don't mention the date. Just mention the WP number because that date and our date should not conflict. Yes.
Item 5.
5 is over, na?
Sorry, sir. Item 6.
6.
But 6 and 7 are same ballot.
What is
same order be passed in item number 3. The same order be passed.
6 and 7.
Yes, ma'am.
Same order. 3, 6, 7 are disposed of. Yes.
Item 8.
Yes, sir. It is 8. Go to the prayer.
Item 8.
8. Your number 8. 8.
petitioner was engaged as Gana Shikshak.
Engaged as
Gana Shikshak. I had annexed 1.
Gana Shikshak.
And I kind of have a
Prayer.
but to permit the petitioner to go on in service city training. I have continuing as Gana Shikshak since 2008. Until today, though I have represented the authorities for many times, but I have not been given the permission to go in service city training.
On the contrary, my counterparts have been permitted to go on city training, but I am not. And I have earlier approached this Hon'Ble Court, and this Hon'Ble Court gave the liberty to the petition to file a fresh representation to the authority. Though I filed, they did not consider it. I came in contempt petition, but since the contempt petition was filed in earlier, not in appropriate time, this court also permitted the petitioner to withdraw this contempt petition and file it in appropriate time. And because of the financial consistency, filed the contempt petition, so time has been expired, elapsed in the meanwhile. So in the present date petition, I have filed with a prayer that direction may be given to the authorities to permit him the petition to go on in service city training and pay also on trend scale of pay.
Which are the rules?
My lord?
Which are the rules?
Rules, my lord, kindly see annex engagement order, page 18.
Engagement order.
Page 18.
What does it say?
My lord, kindly have a look. Lagan Sidhu, and so he is hereby engaged as Shikhyak in Dalia PS Primary School on Nodal UP School, so and so of Gondia Block on execution of an agreement with the Chief Executive Officer Jila Parishad Dhenkanal, District Collector Dhenkanal, as per the Government of Orissa Department of School and Mass Education Resolution dated so and so 16/2008. For the period mentioned in the agreement on a fixed monthly honorarium rupees 2,000 and rupees 1750 for respectively under Sarva Shiksha Abhiyan subject to the following terms and conditions.
Which term?
My lord.
What is your right?
My right, my lord, since I have been continuing since 2008, let me go on in service returning so that I can impart the education.
No. The resolution of 16/2008, basing on which the engagement order was issued, it speaks that they are to acquire training certificate, training qualification within 3 years. Now it was an appointment letter, engagement letter of 2018. 25 is going on. How he will be given a training in service training, my lord?
But what did you say when a representation were given and our court is known, has the great reputation of directing, consider the representation?
That order.
What did you do with that representation?
That order, I do not have that instruction. Let me get that instruction, what they have done. If it is disposed of, I can supply him.
No, why not dispose of? How many times he should come before?
No. If they have disposed of.
Requested to some notice for the respondents. Call this matter next week. Since a short point is involved. Let us see how the representation are considered. If not considered, what I should do to the employees concerned. Why pick and choose?
Yes.
There should be some normative basis.
Yes, I'll give also supply that.
Copy of the petition. One more copy to your
Yes,
resolution.
Item 9.
Yes, sir.
Then complete your lordship will take up the second connected matter.
Second.
That is WPC
18772.
2 months. Yes. Sorry for the.
Yes, sir.
What has happened in this case, my lord? Essentially, my lord, we are aggrieved, my lord, by the order of the competent authority from Secretary, PDA, in recognizing, my lord, the welfare association of the residents. What has happened, my lord, if your lordship would kindly, for a moment.
Illegal construction of boundary wall.
Your lordship, to get a brief idea, my lord, your lordship will kindly turn to page 40, my lord.
40.
40.
Go to 40.
That I'll be able to make my point before that. If your lordship would see the bottom of the right-hand side, my lord.
Yes.
This is a project, my lord, consisting of 6 blocks. One, my lord, is Keshav at the top, my lord.
Yes.
The down below is Vishnu.
Yes.
Near Vishnu, it is Govinda. At the side of Govinda, it's Narayan. The second one is Madhav. and Sridhar. Lordship got it?
Yes.
So
Almost all the names in Sandhya Vandana Achamana.
My lords.
Yeah.
My lords. My lords.
Yeah.
So this project was taken up by a particular person, my lords. So due to differences, the project could not be completed. A tripartite agreement with the landowner and the two builders were entered into. Then, my lords, so far as Keshav, Govinda, Vishnu, and Narayan is concerned, it was, my lords, built by one builder. Commission was for 6 blocks. It was built by one builder. The second one, which, my lord, is the residents of which are disputed, my lord, is Madhav and Sridhar. At the bottom.
What is the dispute action?
Dispute, my lord, is what has happened, my lord. These people, my lord, of block 1, 2, 3, and 4, they formed a welfare association and they got it recognized to the competent authority. We raised an issue before the competent authority, sir. This is a pre-RERA provision, even though it has several units. It can't be a standalone project because the approval of the BDA, the planning authority, was 1 for 6 blocks. Now, what they have done, my lord, is they have left us, the residents of Madhav and Sridhar, out of a welfare association. The amenities like community center, clubhouse, swimming pool, and other amenities have been denied to the residents of these 2 blocks.
Can't you take up it before the RERA?
But RERA, my lord, it is a pre-RERA project, lords. I am covered, my lord, if the lordship will kindly see by Annexure 1.
Annexure 1.
Annexure 1, the competent authority comes secretary BDA. He is the competent authority under the Odisha Apartment Ownership and Management Act, 2023.
What it says?
My lord, he says, my lord, what he has done, my lord?
Deemed to be an association, not a lot is.
My lords. And unfortunately, my lord, we raised an issue before them. We flagged the issue, sir, that these residents of these 2 blocks have been left out. We have been denied, my lord, permission to use the common facilities. And more so, my lord, what they have done, my lord, the connecting little land which was connecting both these 4 and the 2 blocks have been blocked.
Your essential grievances against the builder.
Again, no, my lords. Essential grievances against the authorities, competent authorities, my lord, action in recognizing a welfare resident association which is not represented by the other 2 block owners. And your lordship would appreciate an Annexure 9. They have done what they have done, my lord. They have, my lord, also without they have, my lord, denied the common facilities which by the builder. Now, my lord, they have, my lord, blocked our passage also. We do not have.
Who have blocked?
No, the resident association.
So association is not a legal entity.
Well, it has been recognized.
Maybe.
It's not a, not, it is.
It may be recognized.
True, my lord.
But it is not a legal.
It's not
association is not
a legal entity. But your lordship would appreciate that.
You feel suit.
No, my lord, what I was humbly praying, my lord, subject to your lordship's kind consideration. We had flagged this issue before the competent authority comes secretary PDA. So at least he hears us and the other side also.
Where is the power to decide?
My lord, your lordship,
this private dispute between the
Section 23, my lord, for Apartments Act. No.
Please read.
Odisha Apartment Ownership and Management Act.
Separate act is there.
My lord.
Yes, please.
2023, my lord.
Read.
Lord, here the competent authority is defined.
For the purpose of what?
For the purpose of Odisha Apartment Ownership and Management Act and for the purpose of recognition of associations. Because now it is mandatory.
The recognition I have understood. You said it about thrice.
My lord, I'm sorry.
The dispute between the flat owners intersect. Or members of the association intersect. Or members of the recognized association and other flat owners intersect.
Your lordship,
how that is to be?
Your lordship would appreciate. Competent authority, my lord. Section 23.
Yes.
Competent authority and its powers and functions.
Yes.
the state government may.
Which subsection gives that?
Section 23, I'm placing section 23. Before that, section 15 of that Apartment Owners Act says procedure for formation of
it's not on formation of association as such.
So 23, Your Lordship, may see the competent authorities' role.
Yes.
The state government may by notification appoint one or more officers not below the rank of deputy collector as the competent authority to exercise the powers conferred on it and to perform the functions within the local limits as assigned under this act.
Which are the functions?
The functions, my lord, subsection 3, my lord. The competent authority shall have the following functions, namely, register the association of allottees.
Which relates to
my issue, my lord.
Which is?
No, that is A, D, E is my issue, my lord. A, my lord, is register the association of allottees along with bylaws on receipt of such application from the promoters, allottees, or apartment owners as the case may be. D, ensure compliance by promoter and association of allottees the provisions of this act and the bylaws by issuing suitable directions. E, resolve, the lordship, that is important, any other dispute which may arise under the provisions of this act, rules and bylaws. Then the competent authority shall have the powers and functions of this act. The CPC is to him. It is summoning and enforcing the attendance of any person, requiring the discovery and production of documents, issue, and so on and so forth. So, my lords, if he does not hear us and does not pass an order, my lords, I am precluded because
you are not in, your association is not part.
My lord, there can be only one association. My humble contention, there can be only one association because the competent the building authorities have given one permission for 6 blocks. So now what they have done, 4 blocks which were completed earlier, they formed an association of themselves, leaving aside other 2 blocks which were developed later.
Which are yet to be developed.
But they have been developed. We have already occupants.
Already
occupants.
There should be only one association.
My lords. It's because RERA, my lord, after if I would have come into the RERA scheme, my lords, they say that each block is a standalone project. Now, supposing a block has now there can be 6 associations if I am covered by RERA. But in this pre-RERA era, one association, because why I say so.
Which year act it is?
Lord, RERA is 2016.
No, but this
Act is 2023. This is apartment act. 2023.
This question is not decided by any court.
I'm sorry, to the best of my ability, it has not been decided.
To take notice, let us issue emergent notice. Who are the parties?
Lord, I have the parties, my lord, is
government.
Balaji Residents Welfare Association, the other one who is claiming that they are the controlling of they are
and BMC and BDA. That is
BMC, BDA, and the RERA authority.
Issue emergent notice. In addition to taking usual steps, it is open to the petitioner to serve a copy of the petition along with all the documents on the panel counsel, if any, representing the respondents.
That's an interim prayer, if you like.
No interim prayer.
Well, at least let that lie over.
Interim prayer shall be considered after service of notice. Okay.
Because now they have blocked that passage which we do not have any
I'm not very sure. Even I was applying. There is if the whether that dispute will come within the functions entrusted under the act. There are such judgments in Karnataka Act which hold that there is no such power. Karnataka also has similar.
I bought out with that.
Just look into, just like.
I'll definitely see the Karnataka Act.
Move it immediately after service. It is open to the petitioners.
May I just only pray, Lordship, may after 3 weeks.
It is open to the petitioner to move the matter soon after service.
Okay. You, Lordship, may fix a date after 3 weeks.
No, I can't fix a date.
Because I'll not be privy to the service returns. That will be the whole problem.
You have to verify that. Find whether if service is done.
But
they can come
that
and
difficulty that
I can't fix any date in advance. In admission stage, if a judge fixes the date, it gives an impression that judge is interested in hearing the matter. Therefore, I do not fix. Next week, unless very special matters.
Your Lordship, just give me liberty to move, Your Lordship.
I have said that.
Greatly obliged, my lord. And this Karnataka Act, I'll check up. I'll come back to your lordship.
Okay. Karnataka Act, read Karnataka Act in the light of the Constitution bench judgment of Justice Hidayatullah. 1960 AR 69 Supreme Court, page 78 or 79.
Relating to this,
what is the power of the civil court? Is discussed under section 9 of CPC. Dhula Bhai versus state of MP. Principles have been laid down. This Karnataka High Court followed in one judgment.
I'll check up whether they have parliamentary provisions.
They have said, yes, like parliamentary, yeah? They say all reliefs which High Court can grant, the civil court can grant.
True.
Okay. 9 is very wide. Even under earliest code of civil procedure, section 9 of the CPC is very good. Page number I do not know. I think 69, page 78, 79, something like that.
I'll do that homework. Okay. Greatly obliged.
Item 10.
May I please your lordship, my lord? 26/12/2022, my lords, for the post of attendant male, my lords, in the School of Hearing Impaired Sunabada, my lords, advertisement notices were issued, my lords.
Your representation is not considered?
No, not considered. It was through mail, my lords. And now the question.
Representation, what is that? Prayer?
My lord, prayer I have 2-4, my lords. My lords, my case is, my lord, I have secured 65.13% in qualifying exam, that is 8th pass. But the opposite party are going to appoint a person having 38 marks, my lords.
65.33?
Yes, the page 29, my lords.
This was given to
page 27, let's see. They have rejected my case, saying that I have not duly attested my 8th pass certificate. But the fact remains, my lord, the 8th pass certificate has been duly attested by the Inspector of Schools, and subsequently an objection has been received, invited, my lords, after 3 years.
Issue emergent notice. Learned AGA on request accepts notice for the respondent. First of matter lies in a narrow compass, therefore call this matter after 3 weeks.
May I pre one? IA is there, my lord, not to fill up the awaiting, my lords.
In the meanwhile,
flag A, lords.
One post.
Only one post has been advertised.
Shall be kept vacant. Vacant.
My lords, provided it is vacant, my lords, because he says somebody has been given.
They are processing. I have given that. They are processing.
Unless all vacancies have been exhausted.
Grateful.
Item 11.
Exhausted already.
Please, your lordship. Your lordship, I am appearing for the petitioner. The mother of the conducting counsel passed away. Thereby we pray for 2 weeks' time.
You are for
OP number 1, Union of India, man.
There is some bereavement. Call this matter after 2 weeks on the ground of bereavement in the family of arguing counsel for the petitioner. Okay.
Item 12.
May I please?
Yes, sir.
My lord, commuted value of pension was allowed and recovered from the pension. 10 years have already been passed. Your lordship's order.
Similar order.
Similar. Yes.
Already recovered.
10 years. 10 years have been passed. 10 years passed. He has already deducted for a period of 10 years. In the meantime, 10 years have been since 2013. 2013.
As per the rules, the amount should be deducted for 15 years. But there is judgment, your lordship already passed the order.
Just looking at issue emergent notice.
It has been amended for 12 years.
First of Learned AGA on request accepts notice for the respondent. First of Learned counsel for the petitioner submits that identical question is being considered by this court in WP number 20681 of 2025. Interim relief has been accorded while order dated 31/7/2025, and therefore similar benefit needs to be extended to his client on the principle of parity. First, there is prima facie force in this submission. Next paragraph. In the above circumstance, same interim order as is made in the cognate WP. Then all this matter along with WP number side. So next. Item 13.
The petitioner,
Yes.
the petitioner was appointed as a library attendant on 23/7/2018 under Annexure 1. His appointment was confirmed.
What's your prayer?
But my prayer is my salary for the period from August 2024 to April 2025 that has not been paid. That is one of my grievances. From May 2025, I am not being allowed to discharge my duties. I have made a representation to the sub-collector cum president of the governing body because I am holding a management payment post.
Let them consider the representation.
Yes.
The short grievance of the petitioner is reflected in the prayer column of the petition, which reads as that. Next.
My lords, there is no proof of communication. Let us file fresh application.
I have made it 19/6/2025. My learned friend says I will make a press representation.
No, there is no, you have not attached anything.
It is not there, but I have made a representation to the sub-collector. All right, I will make a press representation.
Next paragraph. Learned counsel for the petitioner, in all fairness, submits that in connection with the prayer in question, he has already made a representation dated 19/6/2025, a copy whereof avails at Annexure 4.
Annexure 4. Yes, Annexure 4.
Annexure 4. And if a direction is issued for its consideration, his client will be satisfied. First one. Next paragraph. Learned AGA, on request accepting notice for the OP, resists the petition contending that there is absolutely no evidentiary material vouching the making of subject representation to the sub-collector, and therefore, if a fresh representation there would be no difficulty for considering the same in accordance with law and in a time-bound way if all contentions are kept open. With this proposal, counsel for the petitioner is agreeable. First one. Next one. In the above circumstances, this petition is disposed of, reserving liberty to make one more representation within 2 weeks.
Yes.
One more representation of the kind within 2 weeks. And if one is made, the jurisdictional authority, it is duly considered in accordance with law. And the result of consideration is conveyed to the petitioner within an outer limit of 6 weeks. First of all contentions are kept open. It is open to solicit any information.
Yes, sir. As far as the second matter is concerned, my lord, here the prayer is said, but here the petitioner was appointed as an assistant librarian on 5/9/2023, and his grievance is that he has not been paid his salary from September 2024 to April
Same order.
25, and from May 2025, he is not being allowed to discharge his same order.
Same.
My lord, some more time. Six
instead of 6 to 8, you can make that. But so far as discharging function, you should take little.
My lord's
anyway, outer limit it is. Okay. Item 14.
Your Lordship, the petitioner is an employee of aided educational institution, Your Lordship, claiming pension, Your Lordship.
Pension,
Your Lordship.
Similar is not paid to you.
Block grant aided educational institution employee. Similar matter has been fixed up 3rd of September, 3rd week of September.
Emergent notice.
Similar matters are coming on third week of September.
To accept notice for the OPs. Call this matter along with WP number.
That number, item 1 is also there. Today's item 1.
Item number 1, WP number. So, okay. Yes.
Item 16.
Petitioner is class for employee of OUT, paying his regulation from the date of initial appointment. Similar order. Yes.
Issue notice. Party?
Yes.
For number 1.
No, number 3 and 4.
OPA for 3 and 4. Notice to 1 and 3. Call this matter along with WP numbers. Give that.
Item number 26 and 27 also same.
26, 27 also same.
Yes.
Okay. Yes.
Item 17.
Little or similar. This is also the pension matter, like item number 1 and 14. 1 and 14 item. That is the same matter.
Emergent notice. OP is for only OP. Who are the OPs?
OP number 3. The WA is pending there.
No, I am asking you, who are the opposite parties?
OP number 3, madam.
3. 1 and 2 are not concerned.
1, 2 and 3, madam.
Issue emergent notice. Whether AGA is there?
Yes.
All AGA plus AGA?
Yes, ma'am.
Learned AGA is requested to accept notice for the respondents. Call along with serial number 1. Serial number 1?
Yes. Say 1, yes.
Okay.
All right.
Item 18.
In admission, you have to be little faster. By 11:30, I have to complete the admission and I have to take up hearing matters. Otherwise, only admission and keeping them pending in the court corridors. Yes. What is that matter? Permission to sell the property.
Pardon.
Your serial number?
Lordship, item 18.
18?
Yes, sir.
Tell.
Lordship, the petitioner is a scheduled caste person. He has made a representation before the sub-collector to dispose of a portion of his land, which
That is not being considered. Representation. It's a granted land.
Yes, sir, Lordship.
Is there Orissa there is any act like which prohibits alienation of granted land?
Lordship, section 22.
Land granted to SC, ST.
22 of Section 22.
There is act.
My lords, that is for reserve category of people.
That's what. If any land is given, that's called granted land in Karnataka, Andhra Pradesh and Tamil Nadu. To sell the granted land, permission, prior permission is necessary then. Whether similar act is here?
Here, a limited period is within a certain period, he cannot alienate that property.
Okay. Non-alienation period is there. Done. The short grievance of the petitioner is as to non-consideration of his representation made to OP number 3, seeking leave to alienate the granted land by way of sale. First off, learned counsel for the petitioner submits that where such an application is made, it is the bounden duty of the authorities to take a call on that, and that the same having not happened, he needs the assistance of the court. First, next paragraph. Learned AGA, in all fairness, submits that he would instruct OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation at Annexure 2. Within an outer limit of 8 weeks, if all contentions are kept open. First up, petitioner's counsel is graciously agreeable with this proposal. First, next paragraph. In the above circumstances, petition is disposed of. Time for compliance is 6 weeks. It is kept open. Next, it open to solicit, etc., etc. Now, no cause. Yes.
Item 19.
Grateful, Your Lordship.
And
in this case, in similar matters, Your Lordship has already issued notice.
you should notice. Same order has been follow along.
Item 20.
20.
Item 20 pass over.
Pass over. I will help you. Just turn the pages.
RSCP matter, my lord.
RSCP matter.
Second time litigation.
Second time. Similar matters we have already admitted. Where we should notice already.
My lord, so this is relates to OUAT.
OUAT.
That is a
You are not party.
autonomous.
You are also party.
No.
Not issue emergent notice. Along with WP number. Similar matters were there, na? In the third week of September. That you also raise. I do not know on that. Okay. What's your name?
AP Amarendra Prasad
Sahu.
Yes.
Okay.
Item 21.
Next.
Mr. Lordship, is the second round litigation, my prayer is Miller. The prayer only that to disburse the area salary from 1/6/1994 to January 2009, my lord.
They have not discussed the salary.
Challenging the second round litigation, I am challenging Annexure 8, the order of the Commissioner, page 41.
They have rejected it.
They rejected, my lord.
On what ground they have rejected?
On the ground, my lord, the question is there, my lord, with these 3 person employees, along with other 6 employees, total 9 employees, submit a file one JA case before the Learned Education Tribunal, my lord. Then that order, my lord, the tribunal allowed my case and passed the judgment. Page 22, your lordship, page 21. Passed the judgment and directed the authority area deeds, my lord. Thereafter, my lord, the state government filed the FAO. The FAO was also dismissed. Page 30, my lord. After dismissal of the FAO, my lord, the authority concerned, page 31, Annexure 4 series, allowed and directed the principal to submit the bill of only the 6 employees, excluding these 3 persons, my lord. So, the 3 persons submitted application before the authority.
No, they have said the block grant was given only in February 2009.
But the GIA already allowed, my lord. Thereafter, 9 persons, but 6 persons allowed, excluding the 3 persons. We are also in that GIA case. That GIA case allowed, and the FAO was also dismissed. Thereafter, the authority paid the 6 persons, directed the principal to submit the bills of 6 persons, excluding the 3 persons. So, these 3 persons submitted the application before the authority 36. Thereafter, filed one writ application before your lordships. This Hon'Ble Court directed the authority to take a decision in his case, my lord. But though they have, your lordship, turn to page 41.
No, I have read that.
When the GI case allowed and FAO dismissed, and from the 9 employees, 6 persons salary already paid, deducting the 3 persons. So how they review the judgment of the tribunal and the order of your lordships, my lord?
Take note.
In fact, there is alternative remedy. They have to approach the tribunal for execution of the order.
In CIA, you were not parties.
I am the party. We
are the party.
Yes.
This is not the.
And in the FAO also we are the party. FAO, they are FAO dismissed.
No, if, there is a provision for execution.
But the authority directed.
1 second, he wants to. You will not allow him to argue. Yes. So there is already.
So we'll file counter in this case.
Yes. AG to accept notice for the respondent. Yes.
Returnable date fixed.
Let us see.
Item 22.
Like, I will solve the
22.
Supposed to be. Second.
I will solve the outline.
Item 22.
Yes, sir.
And on the death of my father, by the legal heir certificate was issued and cancelled without issuing notice, my lord.
It is cancelled without notice.
Without notice.
Why, brother, no, cancelled without notice?
My lord, that so far the appeal is concerned, it is a page 30, my lord, annexer 4. Bhagan Vishal.
What they said. You have filed appeal on against that.
Yes, ma'am.
Appeal is rejected.
No, in appeal, certificate was issued and appeal was filed. And without my knowledge, appeal has been filed and without notice, order has been
allowed the appeal. Appeal is allowed and your certificate is
cancelled. Yes.
You were not party to that.
But I don't know, my lord, but because
my lord, there is a party. Yes. So far the open number 2 is concerned, he is party to the proceeding.
Yes. No, provision for review.
There is a provision for appeal, my lord.
No, against this.
Yes, ma'am.
Appeal.
Against the order of the Tahsildar, there is a provision of appeal which they have preferred under page 30 at annexer 4. The appeal has the other side, ma'am. So that has been disposed of.
But in that he was not a party.
I was
a party.
Yes, I was a party, but no notice was issued and order has been.
No notice was issued to you. No. Where have you stated in your petition?
Yes, but not kindly say without.
Mr. Monty, where the order says appeal notice was served on the respondent.
Yes. And that is after 4 years of the certificate was issued. Page 2, para 12, your lordship.
Issue emergent notice. He is requested to accept notice for respondent number 1 alone.
The 4 mail. OP number 4.
OP number 4. Then who are 1, 2, 3?
4 to 8.
Here, my lord, so far 1 to 3 is concerned, government can accept notice.
1 to 3.
So far 4 to 10 is concerned, they have to issue notice.
4 to 10. 4 to 10. They are sought for interim order.
Interim order, stay of it.
Stay of impugned order till the next date of hearing. The repeated assertion of counsel for the petitioner that though his client was made a party to the appeal in question, no notice was served on him. And thus there is violation of principles of natural justice.
And another submission is that civil suit is pending. Before that is admitted.
He also notifies to court the pendency of civil suit in CS number?
Civil suit number 1021 pending before Civil Judge Senior Division, First Court, Cuttack.
No, you have to say, what is the communication skill? It's so poor. To whom you are addressing? Who will write down? Nothing.
Civil suit number 1008 of 2021. It has. Before the learned Civil Judge Senior Division, First Court, Cuttack.
Okay. Okay. Next.
Item 23. Madam, on behalf of T.R. Meher, 2 weeks time.
2 weeks you want?
Madam.
Wait, what is the matter? Suppose if it is good matter, do you have objection for me to admit it?
I have no file.
You don't have file at all.
This is, my lord, the annexer 7 is the impugned order, wherein the order has been passed. So let notice go, my lord.
Issue notice.
Revise of the pension.
Returnable within 4 weeks.
Item 24.
Please, my lord.
Yes.
My lord, the annual increment of the petitioner has been held up since 2012, my lord, due to pendency of criminal proceeding and departmental proceeding, my lord.
What happened to criminal proceeding?
But that has not been that has not been completed, my lord, yet.
It is still pending.
Yes, my lord. and covered. This is covered by division bench and single bench order of
Saying
this.
that even if criminal proceeding is
Yes.
pending, still you are entitled to
Yes, my lord, because I am discharged.
representation you have given.
Yes, my lord.
Annexer 6 is the representation.
To whom it is given?
It is given to the block education officer.
You consider that representation?
I read as a OP number 3.
Okay, number 4, my lord.
I'm sorry, OP number 4.
4.
Yes, ma'am.
If they consider your representation, all right.
My lord, in the light of this judgment, my lord.
Give that. What is your client doing?
Yes, assistant teacher, my lord. And since 2012, he is not getting, my lord. Yes, sir.
The short grievance of the petitioner who is serving as an assistant teacher in a government school is as to non-sanctioning of annual increments on the ground that disciplinary proceeding coupled with the criminal proceeding in respect of a particular delinquent act or pending. First off. Learned counsel for next paragraph. Learned counsel for the petitioner submits that her client has already given a representation dated
Dated 3/5/2020.
a copy whereof at 6, wherein she has requested for sanctioning of the increments that have been pending since years, keeping in view the coordinate bench decisions of this court in WP number 1335 of 2022, sorry, writ appeal number 1335 of 2022, arising the order passed in WP number 8484 of 2022. First, counsel for the petitioner submits that her client would be satisfied if a direction is given to consider the representation in the light of the said decision. First off. Next paragraph. Learned AGA appearing for the OP is fairly agreeable of the for consideration. This is appreciable. Next paragraph. In the above circumstances, petition is disposed of. Time for consideration is 6 weeks, which should include communication of the result of such consideration to the petitioner. First of all, contentions are kept open. Next paragraph. It is open to solicit. No courts.
Item 25.
Yes.
Case 62 is the impugned order by virtue of which the HPC has not recommended the case of the petitioner for opening of a school. In fact, my lord, the school was opened in the year 2019. Sorry, 2009. At that time, your lordship may turn to page 30.
First time matter.
Yes, madam.
Let him take notice.
Yes.
Emergent notice. Learned AGA to accept notice for the OPs.
Item 28.
What is this 28? Yes, brother. Passover. What is this matter? I will assist you. Come and open the file.
Challenging the
What is that you are challenging? Give that file. What is that annexer?
challenging
625 order.
Yes.
What is that order? But you are sitting in the court hall without studying the pages of the file.
Sorry, ma'am.
Regulation of Ganashikya.
Issue emergent. Heard learned counsel for the petitioner. First of issue emergent notice. Learned such notice for the OPs. All this matter along with WP number.
Review to 226 of 2024.
226 of 2024.
Yes.
No, we have one.
No. That is review petition. That has been dismissed.
Not that. In the third week of September. Okay. Next.
Item 29.
Yes.
The petitioner has in the of the opposite official school of opposite partner 5, my lord.
Approving his service.
My lord, my lord, the reason is, my lord, one opposite partner 6 is no more connected with the school if had a GI 9 because the notification issued by government under annexure 4, 8, my lord, to one post of peon is admissible to the Madhya 12, my lord. Annexure 4, page 19. Thereafter, the opposite partner 6 which is no more connected with the college school, he filed a GI case. GI was dismissed during pendency of GI. I filed the managing committee opinion number 5, submitted proposal to opinion number 3. No action taken because pending GI. After dismissal, again kindly see annexure 6, page 37, proposal submitted by the opinion number 5 to opinion number 3, which is still pending.
Against that order, FAO is waiting.
That is also pending.
Yes, yes.
FAO, my lord, that I submit. FAO, man is of 66 years. Opinion 6 is the age.
When government advocate speaks, you have to permit him. Unless your client has instructed, don't allow the government advocate to speak at all. I
mentioned FAO has been filed by the opinion number 6. I mentioned paragraph page 8.
That way, any interim order in the way?
No interim order. No interim order.
We'll call this matter along with way.
FAO number 532 of 2024.
Issue emergent notice. Learned AG is requested to accept notice for the respondents. Call this matter in the third week of in the second week of October. Any in October.
Needed September, madam.
In the third week of September, along with the FOA number
532 of 2024.
Is it before this court only?
Yes, yes. Now, minus. Madam, black man.
Item 30.
Yes, sister.
In this case, 3 parents before your lordship as 3 petitioners. They want to protect the rights of their respective children, madam. They are studying in opposite party number 5 is providing accommodation to their children, madam. And he also providing the assistance to prosecute their studies. In this case, madam, in the 1/8/2025, is yes, madam, let appear in this matter.
Yes, ma'am.
Similar
for opinion number 5, madam. In that case, it was a WPC number 21763, my lord. Not posted. It was after 3 weeks, my lord. In the meantime, what happened? We have applied for I'm providing the boarding facilities, my lord. Now what happened when the matter is pending? The district administration is forcing us to vacate the children. They are handing over the children. Therefore, their education is affected.
Which is that matter?
That is WPC 21,763.
AG is requested to accept notice for.
My lord, I am appearing for intervener.
Yeah. AG is requested to accept notice for the respondent. So please, intervener application along with the main matter. Call this matter along with the WP number
21,763 of 2025. Right now.
I have given the copy.
Give us for this matter along with this.
Interim protection. There IA for
considered along with the when matters are next posted after service. Okay.
A date may
next.
along
That is fixed already. Yes.
Item 31.
I have a prayer, my lords, in this case. I am a retired headmaster. My pencil paper, etc., has been submitted by the state 1 to 3. I don't have a grievance at all. Opposite party number 4 is asking for certain queries, which the state opposite parties have complied once and twice. Again, the opposite party number 4 asked that you complied, as a result of which I am not able to get my detachable benefit on 31st of March 2023.
21/3/23.
I retired from the service 31st March 2023. The state opposite parties have complied by submitting the records to the opposite partner of 4.
4. Who is 4?
That my lord, it is
Controller of accounts.
accounts of Orissa.
AG is issue emergent notice. AG is requested to accept notice for 1, 2, and 3. Is there any panel counsel for R4?
I don't know. Is there any panel?
Yes, Patra.
Yes, ma'am.
Patra.
My lord may write Mr. Patra who generally appears.
Yes, Sri Justice Patra, panel counsel, which is that Patra, is requested to accept notice for OP number 4. First off, since grievance is of the pensioner of the retired employee as to non-sanctioning of the pension, come on, call this matter in the second week of September. Okay.
I will serve copy to them.
Next.
Item 32. My lord, I am on behalf of Mr. S.K. Sahu. The matter is relating to sanction of pension and pension.
Case. Similar division bench is sitting over the hearing the matter. So that has been posted to third week of September.
But in the meanwhile, you accept notice.
Yes.
Then we will say what will happen.
Yes.
EJ is requested to accept notice for one OPs.
Item 33.
Well, this is a case of transfer. Your Lordship may kindly turn to Annexure 3 at page 17. Well, I challenge the order of transfer. My first ground is I am a kidney patient. And my second ground is I have been transferred to a place which is more than 150 kilometers from the present place. And the third ground is, well, I became a regular teacher only with effect from 9/1/2023, and I have just completed 2.5 years. The normal tenure is 6 years.
No, 6 years, it includes earlier service also.
My lord, so, my lord, the main ground is I am a kidney patient.
What
my lord, I have annexed.
Nature of
Your Lordship may kindly turn to Annexure 5 series. I have given all the prescription. I was under treatment.
All right. Whether that kidney disease cannot be treated in the place where you are posted.
Yes.
Where have you stated?
My lord, sure. Your Lordship may kindly see the name of the school. The place to which I have been posted, that is Government Upper Primary School, Jaldi.
No, I am asking you.
There is no facility. There is no facility. And I have just completed 2.5 years.
No, not just that, but it is only regularized. You are counting it from the date of regularization.
Yes.
But I have held that
prior to that, so far as junior teacher and Sikha Sahayaks are concerned, they are not holding transferable post. Only a regular teacher is holding a transferable post. And a regular teacher who has completed 6 years of service, he is liable for transfer. That is as per the scheme.
Retention period is 6 years.
Retention period, but I have annexed that.
But ordinarily 6 years.
Ordinarily 6 years, but 6 years as a regular teacher, because that is my interpretation. Because so far as junior teachers and Sikha Sahayaks are concerned, they are not.
Any seniors in your school? Well, or you are the most senior?
No. I am not the most senior.
There are other seniors?
Other seniors are there. Nobody is coming to my place. And I have given all the prescriptions.
No, where have you stated that the treatment is not available in the...
It's a remote village. Your Lordship may kindly see the transfer order itself.
No, that's all right. From that village,
yes,
the medicinal facility, medical facility,
nearest,
which is the nearest.
My lord,
that is certain. I will call this matter tomorrow.
No, my lord, I am under treatment at Cuttack.
No, I am asking you.
Yes.
Suppose if treatment is available in the nearby place.
Nearby place, my lord, there is no.
Let us
there is no such facility.
We will ascertain that.
My lord.
Whether our doctors are here, whether court doctors are here.
Yes.
You have a court doctor.
Court.
Dispensary there.
Dispensary there.
Kidney treatment, my lord. He is a nephrology patient.
No, for all diseases of kidney, they are called nephrological disorders. But it is only that.
Here, your Lordship may kindly see the prescription itself. That is under Annexure 5.
Is it undergoing any dialysis or such other
Well, he is under medication, but the difficulty is he is staying with his family. And my lord, if he is transferred to a place which is 150 kilometers away from the present place, my lord, he will face difficulties. Otherwise, he will not have appeals to your lordship.
Family should also go with him.
My lord,
Why?
my lord.
Sita went along with Rama to the forest. No, that is no ground. Just ascertain.
Yes.
We call this matter issue emergent notice. Learned AG requested to accept notice for the respondents. Counsel for the petitioner asserts that his client being a patient of nephrology, there is no near facility, nearby unit where treatment can be, medical treatment can be availed. This needs to be ascertained from the concerned department. Call this matter tomorrow, day after tomorrow. Yes.
Item 34.
Please, there are 3 review applications. Of course, I am appearing in the first review application. My Lord Prime Mr. Das is appearing in the other 2 review applications arising out of
same matter.
Same matter, common judgment.
Review.
To review, I asked that question. I have tried my best to satisfy your lordship with the subject.
Early judgment, you read it other day.
Sir, Judge, let us look to the statute and the other provision. Then, sir, I'll take your lordship to. You also look to, because it has a far-reaching consequence. Because large number of FAOs filed under section 24B of section 6 has been disposed of by this court by coordination. That's a different question. But so far this aspect is concerned, your lordship, no. I tried to verify, but a single case where this question has been raised and answered. Now you also kindly come to the Constitution. Article 225.
225.
Yes, sir.
Yes.
Sir, before I start, I can...
Please read.
Yes, sir. So they also kindly have a movement. My Lord is saying, let us see the statute, then we'll go to the judgment and the other ways.
So you can go to
Right, sir. Right, sir. Right, sir. He has his own way of preparation.
Of course.
I have my own preparation.
I appreciate him also because he's
Sir. Article 225. Jurisdiction of existing high courts, subject to the provisions of this Constitution and to the provisions of any law of the appropriate legislation made by virtue of the power conferred on the legislature by this Constitution, the jurisdiction of jurisdiction conferred on that legislature by the Constitution, the jurisdiction of and the law administered in any existing high court and the respective power of the judges thereof in relation to the administration of justice in court, including any power to make rules, of court and to regulate the sitting of the court and of members thereof sitting alone or in division courts, shall be the same as immediately before the commencement of this Constitution, provided that any restriction to which the jurisdiction by any of the High Court, that's not very much relevant. Now you also kindly come to the Orissa High Court rules. This Orissa High Court rules has been framed pursuant to the Article 225 of the Constitution. If your lordship will look to the Orissa High Court rules, if your lordship, I am straightway taking to your lordship, there are various other provisions, how it will be filed, appeal, how it will be civil appeal, criminal appeals, then the other applications arising out of difference, just like this, that all have been dealt with, the manner in which it has to be presented. But so far the review is concerned, you also kindly come to chapter 8. That is at page, I think you also book. This book. I think you also is holding this. Yes. My Lord friend of that book. If you also look to chapter 8, clause 1, that is at page. You also book 44. The rule of chapter 6 shall apply. This is procedure before admission. The rules of chapter 6 shall apply so far as may be to every memorandum of appeal, to every memorandum of objection under Order 41, Rule 22 or 26 of the Code of Civil Procedure, and to every application for revision or review. Then your lordship kindly turn to Rule 8.
1 second.
Sorry, sir.
These rules are made under which?
Sir, Article 225 of the Constitution.
Where do you find it?
Sir, it has not been stated, but every High Court have any rules. Here, of course, I must bring to your notice letter patent appeal, which is a provision of the Patna, the parent High Court is Patna, that has been borrowed here, and the letter patent appeal is being filed in writ appeal, sir. Earlier it was AHO, now it has been converted to writ appeal. So that is under this High Court rules. That is also yours. That is another part that is admitted. But my humble submission is this High Court rules has been framed in terms of the provision under Article 225. I have seen that judgment, but I could not able to get it, but I'll find out and I'll give to you. I undertake that. Then kindly come to sir, clause 11. Clause 11. Sorry, rule 11.
Rule 11. Yes, 47. Every
application for review made upon the ground of the discovery of new and important matter or evidence within the meaning Order 47, Rule 1 of the Code of Civil Procedure shall be accompanied by an affidavit of the applicant or his advocate stating in clear terms what such new and important matter or evidence is, the effect or purport thereof, and that the same after exercise of due diligence was not within the knowledge of the applicant or could not be produced. Same language as provided under Order 47, Rule 1.
The duplication of the language.
Duplication. Practically,
it is about ground.
Right.
It's more on
ground, sir.
Not jurisdiction to take up review.
Sir.
It is on jurisdiction.
Yes, sir. Sir, Chapter 8 deals with before admission, which includes the application for review and
power to review.
Power to review. Power to review. Yes, sir.
Where is that?
Sir, that's not sir. Sir, because you also again look to Chapter 8. The first one is this: the rule of Chapter 6 shall apply. You also come to Chapter 6. Chapter 6 at your book at page 35. Yes. Part 2, procedure and practice, Chapter 6, general, page 35.
Yes.
Procedure and practice. Part 2 is a procedure and practice, Chapter 6. General rule regarding application and affidavit. Every application to the High Court shall be a petition written in English language. Then you also kindly turn to kindly straightway come to page 41, page 40. Page 40, Rule 27B. All miscellaneous applications and petitions, includes review petitions filed in the following cases shall be registered as miscellaneous cases. Then also kindly come civil cases, like civil review, civil revision, criminal cases, then 28. Every application, memorandum of appeal, and cross objection shall include a synopsis and a list of dates and events in separate sheet and shall be presumed along with the duly filled up coding sheet in index and a list of documents accompanying the application.
They only say continuous.
Yes, sir. Yes, sir. Yes. The form is at page 42, Appendix 8, Roman 8. Review petition arising out of appeal. Kindly come to Appendix 8. That is at page 42, third one. Let's get it.
Yes.
Appendix 8, Roman 8, review petition arising out of appeal.
Yes.
Then kindly come to page 149 of your Lordship's book. That is the format, Appendix 8 of the review. 149. In the High Court of Orissa, Cuttack, Chapter 6, Rule 28, review petition out of appeal.
These are all formats.
Sir.
Where is the power to review?
Sir, this is the Orissa High Court rules. If your lordship says that there is no specific provisions for appeal arising out of the Tribunals Act or Education Tribunals Act, that is covered all the matters which are being filed. Maybe a civil appeal, maybe a criminal appeal, maybe also miscellaneous appeal. That is my submission. Your lordship will consider. That is one. Then your lordship may kindly come at this juncture. My friend has prepared at this point. He will address your lordship further. But I have a different point. Orissa Education Act.
Education Act.
Yes. Your lordship straightway comes with section 20. Your lordship had seen on that date, but for the present purpose, I am trying to take your lordships to the your lordship is holding this book. Yes. Your lordship straightway come to page 160, 159. 15924B, which yes. Kindly sir, come to page 158. Your lordship's book. Same book I am holding. Constitution of the Tribunal, that is under section 24 capital A. Does you get it? Sorry.
Yes.
158 at section 24 capital A.
Constitutes
Constitution of Tribunal. The state government.
Number 2 shall consist of who are the members.
Persons,
Number 3, shall have the power to call for.
Yes, sir. And 4, all this that consequences. This is then kindly come to 6. The order passed by the tribunal shall be enforced under the Code of Civil Procedure in the same manner as if it were a decree of the Civil Code. You also may say this once order is passed, that will be treated to
that is for enforcement of
that is so. Then kindly come to 24B, adjudication. This was incorporated in year 1998. 24A was incorporated in 1978, but this was incorporated in 1998. You also see that adjudication, tribunal shall have jurisdiction. Then kindly come to subrule 5, subsection 5. That is at page 160. 1.5. The tribunal, let's get it.
Yes.
The tribunal shall not be bound by the procedure laid down in the Code of Civil Procedure, but shall be guided by the principle of natural justice and subject to any rules made by the government shall have power to regulate its own procedure. Sir, now kindly come to the rules, sir. Sir, I am taking to your lordships to the rules. That is Orissa Education Tribunal Rules 1977, page 938. Page 938. You get it?
Yes.
You also see that this has been made pursuant to section 27 of the Orissa Education Act. I am reading the preamble. Where are the certain draft rules, so and so, so and so, so and so. Subsection 1 of section
938. Page.
I think you also get it. Page 1, 938.
938.
Yes,
I got it.
Now, so look to the preamble. This rule has been made pursuant to section 27 of the Orissa Education Act.
Yes.
Sir,
that rule making power. Does it include review power?
Sir, rule making power is there.
What are the items enumerated under the delegation point?
There is no specific, but it is extensive power. Sir, power to make rules. You also look to page 165. See, wait up, come with 165.
165.
The state government, sorry.
What do you mean there? Section 24, capital A, comma, 24B into brackets 5, comma, 27. Yes. Let us see the state power to make.
Yes, sir.
Yes.
The power to make rules. The state government may.
It's a general power.
General power, yes.
Then in particular?
In particular, and without prejudice to the generality of the foregoing power, the state government may make rules to regulate the establishment, recognition, and management of private educational institution, be in respect of all matters expressly required or allowed by this act to be prescribed, all rules made under these sections as soon as maybe the manner in which it's placed, we are not concerned.
So, see this, how it is beautifully structured. Common pattern is followed. In particular, and without prejudice to the generality of the foregoing provision, the state government may make rules to regulate the establishment, recognition, management of private educational institutions.
Sir.
B. In respect of all matters expressly required,
allowed by
rules. Yes, sir. Review power should be expressly allowed.
Sir, kindly look to 4. Maybe relevant for your lordship, sir.
Until rules are made.
Until rules are made under this section, the rule contains in the Orissa Education Code, which were in force immediately prior to the commencement of the coming into the force.
That will not come to your aid because rules were made now.
Sir, kindly, sir. In so far as they are not inconsistent with the provision of the Act or of the Constitution, be deemed to be rule under the
to you,
sir,
that will because already rules are
sir, because the constitutional provision under Article 225, I am referring to your lordships to show that Article 225 has been exercised for the purpose of making the rule High Court rules. So High Court rules provide the procedure, and that is a provision of Order 47 Rule 1 to be applied.
One second. Now you took me to 4.
Sir.
See how the section runs. It begins until.
Yes.
No, that's over now.
Sir,
rules are already made.
Sir, again I'm reading, sir. Until rules are
made under this section.
So far that part is concerned.
Yeah.
The
rules are made.
No, sir. So, little bit, sir. The rules contained in the Orissa Education Code immediately prior to the commencement of the rule of this Act, sir, in so far as they are not inconsistent with the provision of the Act or of the Constitution, be deemed to be rules under this Act.
That is until rules are made.
No, sir. Because my respectful submission is, if Lordship will go through this provision, my interpretation is, if there is no provision under the Act or the rules made thereunder,
that section, that is not the language.
Or a rule is framed. Or a rule
you have to manhandle that part.
Sir, I'm ready. Sir, my satisfaction will also kind. Yes, sir.
Now let us come to that word, meaning of the word until.
Until, sir.
Yes.
What is meant? I'm reading, sir.
Yes.
Until rules are made under this section.
One second. Kindly halt.
Sir.
There is comma. Therefore, you have to halt.
Comma. Yes, sir.
1 second. Now let us halt. Comma is for the purpose of halting only. It's a speed break.
Yes, sir. Yes.
It's a speed break.
Yes.
It's a condition also.
Yes.
Until rules are promulgated under this provision, made under this provision. Okay?
Yes, sir.
But that is not a case because rules are already made.
Sir, again, the further also has to read the whole. Rules contained in the Orissa Education Code, which were in force immediately prior to the coming into force of this Act, shall,
unless they are inconsistent, shall be applicable.
In so far as they are not inconsistent with the provision of the Act or the Constitution, be deemed to be the rules made under this Act.
2 conditions are contemplated by the legislature.
Yes, sir.
Number 1 is primordial condition. It says until the rules are made. Number
Yes, sir.
1. Even if rules are made,
Yes,
you are going there.
Yes, sir.
There is difference. Until the rules are made is interpreted by apex court. Take out that judgment.
Sir.
Call librarian. Hakim looking Supreme Court on Words and Phrases by Surendra Malik.
Sir. So my interpretation is taking
This is
note of
number
your
1.
Yes.
Number 2, there is another condition. Not only this. This is first condition. It's the threshold. Threshold is have been made, should not have promulgated any rule. Only then you can travel to this. If they wanted to say, notwithstanding the promulgation of the rules made, the rules then under the code shall be applicable, provided that they are consistent with the same. That is not the language.
That's it. But my respective submission, subject to your lordship's acceptance, is even if the rule is made until word has been used, if the entire provisions is now read altogether, so even if the rule has been made, there is a provision in the rule, then either the Orissa's education code or the constitution will be made applicable, will be followed. And so far the constitution is concerned, it is not required. It is always supreme.
Right.
It is always supreme. So even if it is not there, if the constitution has been exercised for the purpose of making a rule, provided you also accept that is the rule for the purpose of review, then that is my submission. Then, sir, the another point I can take your lordship, because my learned friend can argue anything. You know, so again come to the rule. Let us accept for a moment, even assuming though not admitting that so far as my case is concerned, that review is not provided in the. Then lordship kindly come. What is my argument? The lordship kindly come to page 938. Page 938. That is the Odisha Education Tribunal Rules 1977. These statutory rules. It is statutory rules.
Rules.
Odisha Education Tribunal, within bracket, Tribunal Rules 1977. That is at page 938 of your lordship book.
Ask for those books from the library. There is one more by L.C. St. Bridges. Ask that two books to read.
Suppose note kar, Sergeant, please note it. Sir, kindly come to page 944. That rule. Let's get it. 944, chapter 8, Roman 8 of that rule. Yes, straightway come to rule 26. Inherent powers.
Yes.
The tribunal may exercise inherent power for the ends of justice. You also know that for the ends of justice can be as contemplated under section 152 to 153 of the Code of Civil Procedure. Pause for a moment, sir. Your lordship is a well-known, I need not place with your lordship, in absence of any statutory provisions or specific provision either in the Code of Civil Procedure or any statute, if the provision under section 151 can be applied, and provision of 151, particularly of the Code of Civil Procedure, that is inherent jurisdiction for the ends of justice, has been provided under Rule 26 of the Odisha Education Tribunal Rules. I also remember occasionally also said this is an appeal arising out of a judgment of the tribunal. So,
order of the tribunal. Order of it. Yes.
Or the order of the tribunal. So now the question comes, if the lordship will go to the merit of the case, if there is a clear error apparent on the face of the record, if there is a fraud perpetuated for passing this order, then certainly if the lordship will say that this so far as the 151 CPC can be, inherent power can be exercised and the order can be recorded. Can I look to your lordship, give one or two judgments? Because I don't want to, your lordship knows everything. This
inherent power is in exercise of inherent power is included is your submission.
My submission is, even if the labeling of petition as a reviewer, that is not it. The word, the inherent power means if your lordship is convinced that that is some injustice has been caused for the ends of justice, your lordship can recall that order. That is, I am showing your lordship. That's your lordship well aware about the good judgment, but my lord said that
fraud is committed.
Yes.
Clerical errors.
Yes.
Can rule grant inherent power?
Sir, that is again, sir. Sir, so far the rule has been framed in terms of section 27(1) of the Odisha Education Act. The statutory rules.
24B5.
Sir,
that power is not given them. Yes.
Yes, sir. Yes, sir. Kindly look to 5B. 24B5. Subclass 5.
24B5.
Yes, yes, sir.
There is 160.
That is a substantive provision. You also look to again.
160 of that rule.
May I read it? At page 160 of your lordship. book.
160.
160.
The tribunal shall not be bound by the procedure laid down in the Code of Civil Procedure,
but shall be guided
by the principles of natural justice
and subject to any rule made by the government shall have the power to regulate its own
the government shall have power to regulate its own procedure.
Subject to any rule made by the government. This rule has been made in terms of section 27. They shall have to power to regulate its own procedure.
That power is in the government. Parliamentary provision. The DRT.
Yes, no. Kindly read first part of the provision.
The tribunal
shall not be bound. That's an injunction. Legislative injunction.
But that must be, let's read the whole of the provisions.
Yeah.
The tribunal shall not be bound by the procedure, not be bound by the procedure laid down in the Code of Civil Procedure, but shall be guided by the principle of natural justice and
there is a comma to and also.
Okay. Sir, and comma,
yes.
Subject to any rules made by the government shall have power to regulate procedure.
You have been taught.
Sir, made by the government, comma, sir.
We have been taught in the law school.
Sir.
A delegate cannot make a rule contrary to the policy enacted in the parent statute. The standard book on administrative law, Jain and Jain, IP Messi, Basu, SP Sathe,
yes,
all they have treated this aspect of the matter. Even Wade and Forsyth on administrative law, they have treated this. A delegate of power not transcend the policy content of the provision of the Parent Act.
Sir, suppose there is a provision which is in the rule has been made in the provision of the Act, substantive Act. Then in that case, Your Lordship, we can come to a conclusion.
That way, no.
That will prevail. But here, so far as the CPC is not binding, but it
is not binding. When you see the language of
there is
a legislative
sir. The
not.
So yes, sir. It shall not be bound.
There is a legislative judgment.
Sir, then you also kindly read the whole of the year.
Well,
but shall be guided by the principle of natural justice and, comma, subject to any rules made by the government, comma, shall have power to regulate its own procedure.
That subject has to be subservient to the policy.
Sir,
that's your
sir, that's my argument. I'll show you also some supplementing some my judge. And my learned says that is also a little bit relevant. If you also look to 24A subsection 6. 24A subsection 6. You also may say this is in the Act itself. They have said that this provision will be applicable, this provision of CPC will be applicable. But still, there is no bar under the Act to apply certain provision of the CPC. That is my submission.
No, this is for only selective.
Sir. For CPC, a certain provision of the CPC is not excluded under the Act. That is my submission. Subjective answer, sir. Sir, to this judgment. But one paragraph also, I think for your lordships, I will not place the whole of the judgments. Para 25. That is reported where 151 has been dealt with. That is at
which judgment? Just tell me.
Yes,
which year judgment?
2013. I think also I remember. Yes. Ramji Gupta versus Gopi Krishna Agarwal.
3.
Yes, sir. I'm giving a copy of the judgment to us.
Until.
See judgment they gave.
Word until.
Yes, sir.
You don't have latest edition of that book with you. Anyway, it's the book.
Sir, para 25. Various judgments have been referred to in the context of section 151. In view of the above, the law on this issue stands crystallized to the effect that the inherent power enshrined on Article 151 of the CPC can be exercised only where no remedy has been provided for any other provision of the Code of Civil Procedure. in the event that a party has obtained a decree or order by paying a fraud upon the court, or where an order has been the court may be justified in rectifying such mistake either by recalling the said order or by passing any or appropriate order. However, inherent power cannot be used in conflict of any other existing provision or in case a remedy has been provided or by any other provision of the Code of Civil Procedure. Moreover, in the event that a fraud has been played upon a party, the same may not case where inherent power can be exercised. But here is a case, this review application has been admitted by the Honorable Judge, who had disposed of after realizing that such a mistake has been caused. It is an apparent error on the face of the record. I'll show your Lordship if your Lordship will permit me. But at this stage, because your Lordship is hearing on the question of review application, I don't want to take your Lordship to that. But otherwise, it's a telltale, my Lord. It's a telltale. Mathematical.
Wait. The word until is interpreted by the appellate court.
Sir, I'll take note of that. I'll see it very carefully also.
Karnataka Compulsory Primary Education Amendment and Miscellaneous Provision.
We need that judgment. Citation. Give citation.
The provision contains in S14B of the 1969 Act.
Judgment.
There is a judgment. Give that book to us so that we can.
I'm not good. Please.
Give
that book.
Give it to my friend. We will find out. Sir, similar judgments I have brought. I need not to repeat it. I'll give it to Lordship's for reference. But another judgment I had cited on that.
Fine. Based upon your submission now. Sir. Learned senior advocate appearing for the petitioners. Petitioners?
Yes, sir. In the case.
Submits that. This court has got review power. And that power has to be gathered from the text of section 24 capital A, which provides for establishment of the tribunal.
76.
Subsection 6 of section 24 capital A provides for enforcement of tribunal's order under the provisions of CPC, specifically semicolon.
1976. 2 SCC 502.
Section 20, the subsection 5 of section 24 capital B, although excludes the provisions of CPC, comma, it is not, it is only a selective exclusion. In as much as in the very same subsection, government is given rule-making power whereby it can regulate the procedure of the tribunal.
Where is this binding?
In terms of rule-making power, (1977) rules have been promulgated, whereunder inherent power in the tribunal by virtue of Rule 26, on par with Section 151, 152, and 153 of CPC. Even inherent power includes power to review orders, especially when error is apparent on the face of the record or fraud or fabrication is perpetrated. First off, in some cites 2013 Supreme Court
page.
SCCAF.
Both of them. Both are there. It is 2013-11 SCC, page 296.
2013-11 SCC, page
296.
296, paragraph
25.
Paragraph 25.
I would think. The another judgment your Lordship can refer to. That is reported in.
And
civil appeal number 5784 of 2022 disposed of on 23 2022.
Anything new is stated in that judgment?
Same.
Except for Article 141 of the Constitution says law declared by the Supreme Court. It does not say law repeatedly declared by the Supreme Court.
Right.
Therefore, one decision will
is enough. Yes. Provided that the judgment has been overruled by some. Right.
Any other?
Sir, I'm trying to cite another judgment.
Incidentally, he took the court to the provisions of the Constitution, whereunder, according to him, the rules of High Court have been promulgated. That is, rules of the High Court of Orissa 1948. According to him, power to review can be gathered from chapter 6 by virtue of rule 1 of chapter 8 of the rules. Yes.
Another judgment I'm just trying to cite before my Lord begins.
What is the proposition?
The proposition is the parameter provision on section 22 of the DRT Act. Just I'm reading it, the case is same person. About one paragraph. Okay, sir.
Question to make all the citations,
compilation.
Proposition.
Yes, sir. Yes.
Then paragraph.
Right. We'll do it, sir.
That way. Okay, then I'll read.
I'll do it.
I'll
do it, sir.
They are cited that are irrelevant.
Right, sir. Sir, there only I'm reading only one paragraph.
Yes.
To answer the first question, it is necessary to go through section 22 of the Recovery Act, which provides the extent to which CPC binds the DRT. Section 22, Proceed Tribunal and the Appellate Tribunal. 1. The Tribunal and Appellate Tribunal shall not be bound by the procedure laid down by the Code of Civil Procedure 1908, but shall be guided by the principle of natural justice and subject to the other provisions of this Act and any rules. The Tribunal and the Appellate Tribunal shall have power to regulate their own procedure, including the place in which they have been sitting. Then paragraph 3. It must be appreciated that while the DRT is not bound by the CPC, it is empowered to regulate its procedure, subject to compliance with the rules of natural justice and the provisions of the Recovery Act and any subordinate legislation under the Act. This implies that DRT is empowered to use rules of the CPC as part of the procedure to be followed during proceeding. Since the discretion to regulate procedure is conferred on the DRT in section 22(1), this view was accepted by so-and-so case 99.4 reported in 99.4 SCC, page 710, affirmed by the so-and-so. This court further observed, when section 22 of the Act says that tribunal shall not be bound by the procedure laid down by the Civil Code of Civil Procedure, it does not mean
that it will not have jurisdiction to exercise powers of a court as contained in the Code of Civil Procedure. Rather, the tribunal can travel beyond the Code of Civil Procedure, and the only fetter that is put on its power is to observe the principle of natural justice. Thus, as the DRT is empowered to regulate its own procedure, it is not foreclosed Section 10 of the CPC in the proceeding before it, and the argument that DRT is not bound by the CPC under Section 22 of the Recovery Act is meritless in this country.
Because Section 10 of CPC enacts doctrine of sub judice. Yes, doctrine of sub judice is one of the maxims in Broome's legal maxims. Even in the absence of a legislation, the doctrine operated in common law. Section 10 makes it, in fact, Mullah in CPC, third edition or fourth edition, has made such a comment. I'm repeating that. Yes, Mullah says, even in the absence of 10, doctrine of sub judice,
but in that one, my
lead to conflicting judgment.
My argument is not to that extent. My argument is the parameter provision as provided under Section 25 E6.
Provisions of CPC still will be applicable.
That is right. And relying upon a Supreme Court judgment.
Next panel. Then you consider placing reliance on another decision of Apex Court.
1999 for SCC.
1999
710
SCC 710 paragraphs.
Paragraph that has been quoted in another judgment, that is 2014 SCC online. Of course, it is a case of Punjab. Delhi High Court.
Fusion bench.
I'll give it details.
DRT Act name is, what is that name of the
Debt Recovery Tribunals Act. Debt Recovery Tribunals.
Referring to Section 22 of
Debt Recovery Tribunals.
DRT, you can say that.
Financial
Yes.
DRT, which according to him is pari materia to Section 24 5.
B 24 B subsection
5. The provisions of CPC are applicable, and the tribunal in its wisdom can follow the principles of CPC.
As provided in the rule also, 152.
And
the rule 152. 77-6, Rule 26, Rule 26.
Including Rule 26, which provides for inherent bounds.
This is my substance of my argument. That my long friend argue, I only can take permission for Lordship to give a note with all judgments. Any judgment I'll find out, I'll cite you. Okay.
Yes. Lord, what is the proposition?
Yes.
Why are you citing the decision?
This is not the decision. What I am saying, well, at the outset, I have only stated the rules, which High Court rules, which are relying upon. I put it in one place so that only with reference to the rule numbers only. I have not given the rules. Before that ballot, before going to that ballot, I have the submission to reach to that.
Yes.
My response submission is, we are in a position here. Odisha Education Act Section 24 capital C provides a power to file an appeal against any order or judgment, whatever it is of the tribunal, appeal to this Hon'Ble Court by within 60 days of its order. 24C. 24B, that is page 162, man.
24 is establishment of tribunal.
Yes, that will go in that way, my lord. 24A is the establishment constitution of the tribunal.
24A.
Yes.
Yes. 24B is
adjudication by the tribunal.
Yeah.
Whatever the procedure, and this 24B5, that's where that rider of that regard to CPC is with regard to the adjudication before the tribunal.
My lord, kindly correct. This has nothing to do with 24C proceeding. 24C now you can read it because my senior has already placed it 24B and 24A.
C. Appeal to High Court.
Tribunal, any person aggrieved by an order or decision or judgment of the tribunal an appeal before the High Court within a period of 60 days from the date of such order or decision or judgment. This much, madam.
It provides for appeal.
The only forum has been prescribed here. My respectful submission at this juncture, madam, there is no procedure fixed by this Odisha Education Act for the High Court to decide an appeal. So therefore,
no, an appeal continuation of the original procedure.
Correct, madam, correct.
Whatever procedure is applicable for treating the original petition,
my lord,
at the hands of the tribunal,
correct,
will be pro tanto applicable to the High Court.
My lord, my respectful submission is from that I will start, madam. So what I beg to submit is, again I'm just repeating, my lord, for my convenience. 24B prescribes the procedure what you to do, that is with regard to the tribunal, its own procedural things. 24C never.
Dash submits that. Section 24B regulates the procedure of the tribunal. Section 24C gives appellate power to the High Court against the orders, decision of tribunals. There is no provision in the Act which regulates the procedure of the High Court, and therefore the procedure prescribed under CPC as of necessity has to be adopted.
One line more,
which will obviously include Order 47 rules and rules providing.
One more line, my lord, if my lord is putting me. The High Court is to decide its own proceeding as per its own rule, that is called the Odisha High Court rules and the provisions of the CPC.
In support of this, he points out the provisions of Orissa High Court rules promulgated under Article 225 of the Constitution.
My lord. Now, my lord, kindly have a glance. How, if an appeal, my responsible submission would be, now if an appeal is to be presented to this Hon'Ble Court, yes, you will file. But there is a procedure, how it is to be presented to this Hon'Ble Court. That procedure is not available under the Odisha Education Act or under the rule frame thereafter. That's 77. That is not there. There only says you file an appeal. Because legislature consciously made so, because there is a provision of its own, High Court has its own provision, how to regulate its own procedure, and
legislature, according to Mr. Dash, in its wisdom, has left the procedure to be followed by the High Matters of Appeal, in as much as already there is a plethora of such rules.
So now at this juncture, my lord, let us have the rules. What are the High Court has prescribed in different places in that High Court rule? And whatever little I have gathered, my lord, I have put in that way. My lord, kindly comes to part 1. It starts with part 1. High Court, it has 8 parts, my lord. The rule is of 8 parts. Where I want to just bring it to my lord's notice, in what places, in which places, my lord, the review has been dealt with in the rule itself. These are the rules I have placed.
Yeah.
Well, can you see, my lord, this is the part 1. So in chapter 1, place of sitting of the High Court, rule of non-judicial business, we are not concerned, my lord. Now kindly come to, these are the procedure, chapter 3, page 28, my lord's book. I am holding the same book from
page 28, no?
Yes, chapter 3. This is part 1. How the High Court, how it is to function, what are the procedure. Now chapter 3. Jurisdiction of the single judge and benches of the High Court.
Yes.
point out which gives power of review. My lord, this is the jurisdiction of the single judge and all these things. Now, my lord, section 47 is included here, my lord. Here, section letter 47 is included. I will come to wherever it is there, my lord, I will show to my lord. Just I am showing these are the provisions where, my lord, we have a nexus to this case. Yeah. Kindly see, my lord. Now, my lord, kindly see this page 30. What type of applications, appeals are to be presented? Application or appeals are to be presented to this honorable court. That is at page 30, my lord. 18. Roman 18, my lord. Kindly see. Petition arising out of FAO. These appeals, whatever it is filed, what I have to submit, my lord, whatever we are filing the 24C, it is nomenclature. This we got it from this place. And this is the assignment to the single judge. Para 12. Clause 12. All cases of routine nature not involving any question of law or merit of the case shall be placed before the single judge for orders, irrespective of the fact as to whether the case are single judge or division bench cases. And he may, while disposing the matter, exercise the power of dismissal in case of non-compliance, provided that all the interlocutory applications registered as a miscellaneous cases which demand going into question of law or merit would be placed before the division bench if the cases in which those matters arise are required to be heard and disposed by a division bench. These are the procedure. The single bench matter, my lord, that has been nomenclature as FAO. Now, my lord, all these provisions, I will not bother, my lord, to say. Here, my lord, appeal, the word even used here, there is no word of review here in this particular para, but they say the application. Appeal, application, petitions, these are the words used in this entire chapter. Now, kindly come to.
But revision is used.
Yes, revision is, no, my lord, that
22, 17.
Yes, that is there, man. Now, kindly see, my lord.
Revision is used, but review is not.
Review is not the application or petition. That is, I am conscious of that. That is why I placed it. So now, my lord, this 23 may kindly see, plus 23. This is one provision. How, my lord, this chapter 5. Sorry, man, I have to say fast. Chapter 5. Chapter 5, page 32. Page 32, man. Against this part 1. Power of the registered officials of the court. In addition to the power conferred on him, they rule the register shall have the following duties and power. They have to place all these cases in this way. Now kindly turn to page, my lord. That 12 XII, right hand side 33.
To require
any memorandum of appeal, petitions, applications, or other proceeding presented to the court or to register to be amended in accordance with the procedure or practice of the court. What it says is, as I have understood, my lord, any review is not the word review. Word is not there. Yeah. What it says, any application, petitions.
Can we go to other substantive arguments?
Yes, that is there. In this, if I will not go in this way, my lord, I may not reach with my conclusion. That is the difficulty. It may go.
My difficulty is it is miles away from the idea of review. The provisions of Orissa Rules 1948, which Dash mentions, even in milligrams, does not support the view that they give review power. Okay, next.
But what I want to submit, I think, is any application presented, this is the procedure.
Handmaids. These are handmade subjects. They are procedural.
Yes, my lord.
Review is a substantive form.
Obliged, my lord. But one thing I want to say, my lord, unless we go through this procedure, we cannot get the substantial justice. The procedure is, because what I started is...
Mr. Dash,
my lord, yes, sorry, my lord, sorry, because...
No problem. And you are arguing very well.
No.
I can go on reading every page of this.
Yes.
But only thing is, you should ensure your safety at the hands of those who are sitting behind you.
Yes.
They are waiting for their case.
No, because this is an...
Come to the point directly.
Yes, directly I'll come to, unless, because what I have started is, I want to came before my lord. This 24C, just what I have stated of
I made to protect myself from the criticism.
All right. So now, my lord, my endeavor is to do something for my client. That is my endeavor, my lord. Yes, when my learned friends will be there in their turn, they will also protect their rights of their client.
We have to ration the time.
Yes.
We have to ration the
Yes, my lord, let me say. So what I beg to submit is 24C. I'm just repeating it because my lord have said that it has not helped me. This argument has not helped me. Just like that, therefore I'm repeating it. 24C never prescribe a procedure for the High Court to decide that. Yes, sir. The High Court has its own procedure and practice, and it has to be followed. And right from the day of presentation of the appeal, these are the procedure. So it has to be processed through this procedure. Unless this application, either review or appeal, whatever it is, it cannot be taken up by the High Court. So now kindly come to the procedure and practice, part 2.
Part 2.
Yes, just 35. My senior has placed it.
Page number
35. It says rule 1, as my senior has already read it, every application to the High Court shall be a petition written in English language. Every petition shall state concise and clearly all these things. That is, my senior has read it. So this is the procedure. On the application made to this, the appeal made to this Hon'Ble Court under 24C, these are also the procedure. So now with this procedure, my lord, this appeal was heard. And one of such procedure is, therefore because my lord says it has no help to me. One of such procedure, if you go back to that order, that clause 23, page 34, if you go back, one of such procedure, suppose notice is not sufficient, what to do?
To direct in what newspapers the publication referred to in order
civil procedure. So they have to take CPC for issuance of notice to the respondents. In this particular case, that is a fact, my lord, admitted fact. In this particular case, while the matter was placed before this Hon'Ble Court, the review application was made to this Hon'Ble Court, notices was issued by this Hon'Ble Court.
Procedures well and good.
Yes, that is
rightly said. Till up to particular point, I am with you only. CPC, even when CPC is not applicable, therefore I cited that 1982 Supreme Court, that Jyoti Basu Devi Prasad Ghoshal, because the representation of people,
that is no sense.
Even then the provisions of CPC will be applicable. Question is not that. Where is the review power?
Yes, that thereafter I would say that. So these are the position. So now my response submission is at this juncture, madam. An appeal was admittedly filed here. Admittedly, appeal was dismissed or disposed of, whatever it is. So now the question comes, if some apparent error or some mistake, something. So whether a review can be filed. So there is no provision after 24C. It is seized there. But my response submission, the legislature may not have thought of such a situation, because when it has been presented to the Hon'Ble Court, now the procedure is of the Hon'Ble Court, because part 2 deals with the practice and procedure of the High Court. When the appeal is there and some order has been passed, now the order is of the High Court. So once it is an order of the High Court and a review petition is to be presented, suppose some wrong is there. So therefore, our entire procedure as propagated in this rule, High Court rule, has to be followed for presentation of the appeal and also hearing of the appeal. So review is not a bar at that in this type of cases.
That submits that whenever there is error apparent on the face of the record, or there is fraud or fabrication whereby an order has been snatched at the hands of this FOE, come on. As of necessity, power to review has to be conceded. First.
Now I will kindly come to chapter 8.
8 of
that High Court rules.
Page?
That will page 44.
Is 44?
Yes. The chapter 6, chapter 8 starts with page 44. My senior has already read it one, that the rule of chapter 6 shall apply as may be for every memorandum of appeal, for every memorandum of objection, 42-26 of the Code of Civil Procedure, to every application for review, revision or review. Chapter 6 S1, I will not repeat that. That there is a provision, I guess the FAO that is in appeal review application is there under chapter 6. So that much is. Now kindly come to my lord, rule 3. Every memorandum of appeal, every application for review or a revision shall immediately below the title endorse to the first appeal, second appeal, review or revision, as the case may be shall stated in this procedure. So now, my lord, as I have stated, since it is the Orissa Education Act and order is passed by this Honorable Court on that appeal. So now, since there is no procedure, now High Court has by applying its own order, this rule, this High Court rules can have a review petition as it will have gone from part 1 to this chapter 8. Application for review is also presented.
Mr. Das submits that under rules 1 and 3 of chapter 8 of Orissa rules, part 2, there is indication that review power avails to the High Court, which treats FOA.
My lord. Now, my lord senior has already read that, my lord, rule 11, wherein order 47, rule 1 has been taken care of that rule. Every application,
every section, rules 1. What? You need not read because he has read it. I read.
Yes, then I will not want to proceed, my lord. 12 also, my lord. 12 and 13. There also the procedures.
12 and 13.
12 and 13. I have stated it in that note, my lord. Kindly see my note. I have given these rule numbers, which refers to the chapter in page 2 in a tabular form. My lord, got it everything. Whatever I am submitting about this on.
1, 2, 3, 22, 23,
12 and 13. Yes, now from this chapter. Now, my lord, here is also chapter 9.
Page,
my lord, 52.
Procedure after admission.
Procedure after this whatever the chapter 8 was, procedure before admission.
Yes.
And part 1 is for filing of the appeal and all these things, madam. So this is after admission, what was the procedure? Because here in this case was admitted by the Honorable Judge who has heard this matter. Dispose of the appeal. So now, my lord, this says, subject to any order which may, rule 1, my reading, subject to any order which made by the bench, the date for hearing on any suit, appeal or application, or any part of the advocate shall be fixed by the registry. Such and such. Rule 3 is important, man. When an appeal is one which
These
is
are only purely procedural.
procedure. Yes, everything is procedure. That is why my submission.
No, review is not procedure. It is substantive.
Yes, substantive, my lord. But here my only what I want to say, my lord. In one line, my submission is since order passed under that 24C by the High Court. There is no procedure in that another rule. Now, once High Court has passed an order, so High Court will now follow its own order to rectify its mistake, maybe form of a review. And that power is there. This is one line submission.
Shall I use the word lastly or?
And that's why I will show all these provision where it is. Not this is the last submission. Maybe not lastly, but the other provision I will read out just.
Almost lastly submits. The capacity order in FOA. Any error apparent in it has to be rectified by the High Court itself. And therefore, review is maintainable. Such errors having been pleaded in the review petition
Another procedural is chapter 12.
Mr. Das,
Yes.
one incident I should quote here.
No, I have stated it, just I am referring. If I have to go through this, then I need to.
I will go through, I will quote.
Yes.
But this incident is very important.
Fine. Now kindly say.
Once Jinnah was asked, he was offered judgeship.
Fine. Just I'm.
And he said, Jinnah.
Yes.
Have you heard of Jinnah? Jinnah refused to accept the offer of High Court judgeship in Bombay High Court. And read the reason why he offered. I will not tell it in the open court. Perhaps MC Chagla in Roses in December mentions that, if my memory serves him.
And one more submission here.
Yes.
That part 8 of the High Court rules is not printed in that book. Just I am handing over one copy. I have, but I have marked it somewhere.
No problem. I give them.
This also deals with the review. This is not in that book.
These rules are not there.
No, they are not printed in this book. Well, that is the tragedy. I have got it from the internet. It is available. This is our High Court rules, man. Madam, may verify the rest.
Court may review its judgment or order,
but no application for review will be entertained in a civil proceeding except on the
grounds mentioned 47 rules 1.
This is
that your opponent.
Yes, this is
What do you
the
say
last
about
article. This is a. I don't know. Report time to well, it is there.
So, so far as this para 1 is concerned, in terms of the judgment or order,
Yeah.
but
With your lordship kind permission.
Very, very.
no application for review will be entertained in a civil proceeding except on the grounds mentioned in order 47 and 1 of the code, and in a criminal proceeding except on the ground of an error after notification record. This is concerning review civil procedure code.
No, grounds are taken from that. Grounds are taken that. Otherwise, there was no provision, no requirement at all. If CPC were to be applicable, straightway would have jumped there. It is open to legislature to say, except on the ground on which a review lies in London, it can borrow that literature. This rule I had not seen. This rule, in so many words, says, it can say what should be the ground, etc. is another thing. But review is given. We don't say that they have wasted time in finding out these things. It is another learning. Maybe that they have taken more. Maybe in organizing their argument, they may not be knowing which should be cited immediately. It all depends upon the course of argument. This, in so many words, says the High Court may review its judgment or order.
It deals with order 40.
So that's a ground. Ground for review is one thing. Power to review is another.
Yes.
Power to do a thing is one thing.
On what grounds that power can be exercised is another. This is the second part. But substantive part is in the rule itself.
Since this appeal is statutory appeal.
Suppose if appeal is filed under the provisions of the Land Acquisition Act, CPC is applicable or not?
CPC so the procedural aspects are concerned.
Here is it goes one.
The judgment which I have produced before your lordship, that does not say in absence of power of review under that act, the authority is not empowered to go for exercising power of review. In that judgment, in category determinant,
then where was the requirement of this rule? If you agree, this rule is rendered redundant.
So this has to be in what context we have to go?
Read. No, this section is the rule itself provides for that. Power to review.
Yeah, you also grant me some time so that I can examine.
This case will never see the judgment at all. This is of which year? 2012.
Yeah, let me purchase.
That's right. I'll call this matter tomorrow. Just look into it and come back. Now we have to put an end to this litigation.
It works.
Lastly,
This is my last one.
last one refers to Part 8 of Orissa rules, wherein Rule 1 power of review in so many words. Okay. In choosing your points,
I have to learn, my lord. But because this is, I was placing this area, yes, I could have come. It was there with, it is there. But
unless you have a meter, you are charging on the meter basis.
No charging here. If my lord, on the record, my lord asked me.
Straightly, you have cited this.
Yes, I could have checked. It was there with me. That is when my lord was closing the, I kept it as the last submission.
All right. Why these are
yes, other cases, just one submission. This is with regard this argument, what we have done, it is with regard to the review.
Yeah.
But other cases that writ petitions and other FAOs, my lord, these are on the different argument. This has nothing to do with this case. Because it was one college, one institution, different persons, they were clubbed together by the coordinate bench. But this argument is for this review. My lord, may separately.
Power to review is there.
Yes.
Then we have to show what review power is invocable.
Yes.
Invocability.
Yes, yes, that.
So day after we'll have the finance. All, I'm asking all, I'm telling to myself, kindly be brief. I'm telling it to myself. Therefore, I write brief judgments, except where some very complex legal issues are involved. I take little time to script them. Anyway, thank you for the last argument.
I'm sorry, I kill your time, my lord.
No problem. Sometimes it happens. But 2012 matter. At least happen here.
I'm sorry, your lordship.
54. 54.
After launch, I have to do this.
Now you are held up.
I am for the petition. Opposite party is the council.
Are you held up? What you want, lunch or what?
After lunch, I have some popularity.
Lunch, I can take you to my chamber, no problem. You want time or lunch?
Yes, I want time.
You want time? After 3 weeks?
Interim order maybe. Interim order maybe.
4 weeks at the interim order. Inform the other side.
Nice.
Extremely sorry in disturbing your lordship.
No problem.
This hour. But one matter, item 58. 58. But without informing me, the time has been sought for in the first, and that has been adjourned for which, though the matter was fixed as a last chance today. Last chance today, this is your lordship's order. On 29/7/2025. But this is the order, your lordship, considering the gravity of the matter.
58. What the serial number 58 in today's lesson is to tell them not to send it to the post address. See, if it is not signed, I will do something. Yes. Otherwise, you can move a memo mentioning this after serving copy on him. Yes. All right. Yes. I will not be able to do because they seek time at 10:30.
At 10:30.
Sometimes there will be justification also. But when it is written finally, they should tell the court, we have written it finally, but I have difficulty. Yes. That way. That they did not say. I remember.
Well, they should inform us.
At least, therefore, I insist to inform the other side. So the bar came to my chamber and said, sir, if you insist that inform, etc., it is difficult to find out those people. That's also a bit true. But at least some phone can be done.
Sometimes it happens. But knowingly, it was with the knowledge of all the parties that it was fixed as a last chance.
Let us see. If I have signed, you move a memo.
Yes.
If I have not signed, yes, I will post it next week itself. Yes. Okay. 58. Right?
Item 35.
Yes.
Item 35.
But nobody is there, my lord. And the office noting is, my lord, they have not removing the defect in the matter of the year 2020.
When the matter is called out, counsel for the petitioner is absent. First of all, added, petitioner has not taken any steps towards the removal of the defects in time. First off, this is a decade-old matter and it cannot be kept pending eternally like this. First, in the above circumstances, petition is dismissed from non-prosecution. Yes.
Item 36.
Please, Your Lordship. Your Lordship, we had filed the substitution petition, Your Lordship.
What?
We had filed a substitution petition, Your Lordship, in the interim application for substitution of opposite party number 6, Your Lordship.
Would be 6.
Yes, Your Lordship.
Instead of substitution is additional.
Yes,
impleadment.
Yes, impleadment, Your Lordship. Has died.
Why you want to implead?
Because, Your Lordship, on his complaint, an adverse order has been passed against me, Your Lordship.
You was not made a party.
No, I was made a party there, Your Lordship. But
you are for the complainant.
I'm for the opposite party in the proceedings before the collector, Your Lordship.
On your complaint, the proceedings arose.
On the complaint of the opposite party number 6, Your Lordship.
You represent whom?
I was representing the opposite parties there, Your Lordship.
Who is that opposite party number?
Petitioner in proceedings, Your Lordship.
Petitioner is the person who complained.
No, Your Lordship. The opposite party number 6 is the person who had complained before the collector, Your Lordship.
Right, I have understood.
Yes, Your Lordship.
You appear for whom?
I appear for the petitioner, Your Lordship, who was opposite party number 1 moment, Your Lordship. Who was opposite party in the collector proceedings before the collector, Your Lordship.
You were opposite. You are the complainant. No.
I'm present in the
You
petition.
are for the petitioner.
Yes.
That simple, you are not answering. Yes. That OP number 6, you want to implead.
OP number 6 has in the meantime died, Your Lordship. So
Died.
I want to substitute that opposite party number 6 with his legal heirs, Your Lordship.
Legal heirs.
Yes, Your Lordship.
Now how? Where is the heritable interest?
Your Lordship,
Interest should be heritable. Then there can be a representative. If the complainant dies, it's over. He cannot be, he is not a necessary party. He is only a proper party.
it's only a proper, because Your Lordship, earlier they said directed us, so we had filed a substitution.
The impleading application supported by the affidavit seeks to array LRs of the original complainant pursuant to which the impugned order is made. First time. Complainant does not have heritable interest which the LRs could have inherited, which is that section under the Indian Succession Act. Provision, na? Famous judgment of Justice S.N. Mukherjee of Calcutta High Court. First, the LRs of the deceased complainant cannot be said to be proper party, much less necessary party in the light of Apex Court decision in Rajia Begum versus Shah Nawaz Begum, AR 1958 Supreme Court, page number science. First, application is rejected. Then what?
Your Lordship, now remains the merits of the case, Your Lordship. Lordship, the petitioner is the owner of a land, Your Lordship.
Owner of?
Owner of a landed property, Your Lordship.
Make use of mic so that I generally like one being louder and effective. Yes.
So the petitioner, Your Lordship, had entered into a lease deed with Reliance Jio Telecom, providing her land for the purpose of a construction of a mobile tower, Your Lordship.
Or mobile tower?
Yes, Your Lordship.
You had sought for lease of the land.
The Reliance had sought for, I had entered into a lease agreement, Your Lordship.
You are the owner of the land.
I am owner of the land.
You leased your land to Reliance.
Yes, Your Lordship. For construction.
Lease deed dated?
Lordship, the lease date is dated 5th May 2014, Your Lordship.
5/5/2014.
Yes, Your Lordship.
Why are you here now?
Lordship, I am here because the 7, Your Lordship, in the present writ applications, while the tower had been constructed and it was about to be functional, Your Lordships, these people had approached this Hon'Ble Court seeking that the mobile tower cannot be constructed over the said piece of land for various reasons, Your Lordship. So this Hon'Ble Court had given them a direction that you approach the collector of that particular district, Your Lordships. So
what the collector has done now?
The collector has considered their complaint, Your Lordship, and has given a finding that the mobile tower should be from that particular land, Your Lordship.
On what ground?
On the ground that it is violative of the regulations that are governing the functioning and construction and functioning of the towers, Your Lordship.
Which regulation?
The regulation is special regulation for installation of telecom towers in urban areas of Odisha, 2013, Your Lordship.
Regulations are made under which statute?
Your Lordship, this is under the Telegraph Act, Your Lordship, Section 7 and Section 10, Your Lordships.
What are the grounds actually mentioned?
Your Lordship, if I may pass it on to Your Lordship's account.
Since last 9 years, tower is working.
Tower is not functional. Tower is still there, Your Lordship.
There, but functional.
But we could not make it functional because of
Order.
There was.
Where is that order? Take me through.
Your Lordship, the first order number 1 passed in this writ application, Your Lordship.
Order number 1?
Yes, Your Lordship.
Annexure 1?
No, Your Lordship. Order number 1.
What for it is?
Order number 1, herein this Hon'Ble Court had given a direction that no coercive action will be taken
But where is the impugned order?
Oh, yeah, yes, Your Lordship. Your Lordship, that is at page number 43 to 47.
43 to 47.
Yes, Your Lordship.
You were given opportunity. Is it beyond the distance of 36 meters
Your Lordship.
from adjacent houses?
Yes, Your Lordship. Your Lordship may come to the relevant page, Your Lordship. I'll take Your Lordship through it.
You have not taken permission of the pollution control board.
Lordship, that is complied, Your Lordship. They had not made a party. The Reliance had not been made a party over there, Your Lordship. But they had filed an intervention. Your Lordship may come up to page number 3 of that impugned order, Your Lordship.
No, I am asking a question to you. You are lesser.
Yes, Your Lordship.
You are getting the rent.
Your Lordship, apparently when this order was passed, the mobile tower is there. But till now, again, I have filed another case in the District Court for recovery.
You recover?
Yes.
How you are aggrieved by this all?
Your Lordship, I am aggrieved because once I had made deviations on the land, Your Lordships. I had cleared that land up for construction of this tower, Your Lordships.
Tower is constructed.
Yes, Your Lordships.
There is tower now.
Yes, Your Lordship.
And you are pressing your recovery suit.
Yes, Your Lordships.
How you are aggrieved by
Sir,
this?
Your Lordships, if I am aggrieved because if the order of the collector stands, Your Lordship, then I have already faced losses in clearing the land, Your Lordship, and my rent will again be due, Your Lordships.
No, functionality. You have leased it for the purpose of putting up a tower.
Yes.
Tower is put. How it should be functioned, what all regulations to be followed, it is for the lessee. If he has violated the conditions, he suffers an order. How your rent is affected?
The lessee
you continue to be lesser only.
Yes, Your Lordship. The lessee is also a party over here, and the lessee is a party there.
Lessee is a respondent.
Yes, Your Lordship.
He is happy with the order, and you are complaining. When lease is made of the ground, you are the tower. Mullah on Transfer of Property Act treats the doctrine of what is that? It is dual ownership. The doctrine of dual ownership, which in England it operated, in Ireland it operated. Where you give lease, you are the owner of the land. Where structure is put by the lessee, he is the owner of the structure. And the order addresses the structure, how you are aggrieved. And lessee is happy.
Your Lordship, he has
Ask librarian to bring Mullah on Transfer of Property Act. See, all writ lawyers should read all laws. Civil, criminal, revenue, rent, labor, service, whatever. All laws should be, if you see, Shirwa is constitutional law, 4th edition. What an enormity of knowledge. How many subjects, how many branches of law? You are not an aggrieved party. Apex Court has followed that. Bombay High Court judgment it was. I don't remember the name of the judge. That the Apex Court considered. Can anybody take out dual ownership? Bombay High Court and Supreme Court.
Your Lordship, because there was one clause in the lease deed agreement wherein it is said that the lessor hereby agrees and undertakes to ensure that the equipments of the lessee installed at the demised land are kept protected, Your Lordship.
They are protected. You are protecting them.
So,
functionality is not spoken there.
Yes, that is not spoken. But
he is happy.
Your Lordship,
lessee is happy.
No, lessee is supporting my case.
Well, he should have known. He have supported you being the respondent. You have no case. Lessee should come before that. You are pressing the suit for recovery of the rent. On the ground that I am not concerned with this. As long as the lease continues, so long you are liable to pay the rent. Ask them to bring Mullah on Transfer of Property Act. Can you get anybody from Bombay judgment? 1950s judgment it is. Correct.
AR 19?
1956 judgment, Vinay Gopal Limay versus Lakshman Kashinath
Athawale.
Yes, sir.
Correct. That is affirmed by the apex court. Can you find out? Okay, what's your name?
Sir, Suman Gopal.
Okay, very good. No case. What is your OS number? OS number, suit.
Your Lordship, so there was a miscase that had been filed. Your Lordship, the case that I had filed.
Filed for
before
recovery of the rent.
Yes, yes.
That is
Your
called
Lordship,
what?
give me
CS.
Yes, Your Lordship. Civil suit.
How much time it will take for
Your Lordship,
Mullah to come here? I have asked for Mullah's book, not Mullah. I will permit you to prosecute the suit for recovery, but you are not aggrieved by this because you are not the owner of the structure. And functionality is not in the term of the lease.
Your Lordship, but because of this provision.
No. Had you read that judgment, you would not have filed this case. You would have advised your lessee. You file, make me also a respondent. I support you. For 9 years, it is pending here.
Yes, sir.
Right now. Kindly be seated. That brother, he said the Bombay judgment that citation. AIR 56. AR 1956. Bombay, not 50, Supreme Court. It must be Bombay. Is there? Bombay High Court. Vinay Gopal Limaye versus Lakshman Kashinath Athawale. Take note. Petitioner, being the lessee of a plot on which is constructed by the being the lessor of the plot on which a mobile tower is constructed by OP number 7. OP number 7.
Yes, Your Lordship.
7, comma, is invoking the writ jurisdiction of this court for assailing. Go to play. The order dated 1/7/2015 passed by the collector in miscellaneous case number 61/2014, whereby the tower has been rendered dysfunctional. Is there any direction to remove the tower?
Yes, Your Lordship.
Coupled with a direction for its removal. First one. Next paragraph. Learned, kindly be seated. Doctor, be seated. Basant out. No chair. Stand up. Learned counsel for the petitioner vehemently argues that
The subject site was leased in favor of OP number 7.
OP number 5. Your
OP
Lordship.
number 5. While the registered lease deed dated 5/5/2014, subject to certain terms and conditions, and that because of the tower having become dysfunctional, give to anybody, take out that dual ownership under section 54, perhaps, of the transfer of property, or 55. Yes. The tower being becoming dysfunctional and being directed to be dismantled, the interest of the petitioner is hurt. First, even otherwise, Learned Counsel makes other submission for faltering of the impugned order. Next paragraph. After service, the respondents having entered appearance resist the petitions, making submission in justification of the impugned order and the reasons on which it has been structured. First. Next paragraph. Having heard the Learned Counsel for the parties and having perused the petition papers, this court's indulgence in the matter solely on the ground of petitioner not being an aggrieved party, in as much as by virtue of the order, the jural relation of lessor lessee is not affected, much less determined. First, our system, dual ownership is recognized, which Mullah's Transfer of Property Act, latest edition at page number so and so, refers to as under. Next paragraph. It hardly needs to be stated that when lessor is the owner of the plot and lessee erects the structure therein, lessor does not become owner thereof, its ownership vesting in the lessee himself. First off, this view gains support from the Bombay High Court judgment decision in AAR 1956, Bombay, page AR 1957, Bombay 94. 94. First off, the really aggrieved party arguably is OP number 5, being the
owner of the tower in question. And the order addresses essentially the tower and not the plot on which it is erected. Full stop. Next paragraph. Learned counsel for the petitioner agrees in all fairness that a proceeding in a CS
14 of 2016.
14 of 2016 is filed by her client against OP number 5 for recovery of rents that have fallen, that have accrued due. It is ununderstandable as to how the impugned order herein would come in the way of petitioner prosecuting the said suit founded on the lease deed dated 5/5/2014. First stop. Next paragraph. In the above substance, is disposed of, reserving liberty to the petitioner to prosecute the suit, and that the suit shall not be influenced by the impugned order otherwise. First one. Which 2016 suit?
Yes, Your Lordship.
Learned of which judge he is?
Your Lordship, I do not know whether it is the senior division or civil judge Kendra Padai.
The jurisdictional judge is requested to try and dispose of the suit and report compliance to the Registrar General of this court within an outer limit of 1 year. All right, are you happy with this order? Last line. This court of the submission advanced by learned counsel for the petitioner. What's your name, Doctor?
Your Lordship, Binny Mishra.
Fine, so. Fine. Would you get that?
Your Lordship,
No, you can't leave the court hall without getting that.
Your Lordship, I did look into the section so that
it's very easy. Just look into, take help of your friends also.
Yes.
So that you will get more knowledge.
Your Lordship,
Okay. All right.
Item 37.
37, I put on for your lordship. My lord, this is a matter related to appointment under the Rehabilitation Assistance Scheme. My lord, here, three
compassionate appointment.
My lord, appointment. My lord, three dates are vital over here. The date of death, that is 24/12/2006.
1 second. 24/12/2006.
When the father of the present petitioner died, as serving as PT in Sri Jagannath Government School. Then the date of application, my lord.
Teacher he was?
Yes, ma'am.
PE teacher?
PET, my lord. Sports.
Physical education teacher. Physical education.
Yes, ma'am. My lord, the date of application happens.
When who applied?
Son, my lord. My lord, the date of
applied on
6/7/2015 on attaining the age of majority, my lord.
6/7/2015
on attaining the age of majority, which is prescribed under the Rule 9(7) of OCS RA Rules 1990.
97.
97.
Within 1 year from the date of attaining majority.
Within 3 years, madam.
Within 3 years.
Madam.
Rule 9.
Rule 9, clause 7.
He attained majority when?
My lord, a majority in 2015 itself.
2015 means which date? You have to say.
My lord, his date of birth happens to be 96. So, my lord, in
date has to be given.
My lord, for a moment, if application is produced,
you have to tell the date.
1995, my lord, the date of birth is mentioned.
So date give me, not year of birth.
3/5/1995, my lord, the date of birth.
3/5/1995. 95. Then
18 years in 2015, my lord. In
tell me on which date he attains the age of 18. Under the Indian Majority Act 1875, Section 3 or 4, a person attains the age, particular age, a day before his birth date, reckoned from birth date. So, he was born on 3/5/1995. He becomes 18-year-old on 2/5/2003. 2003.
13.
2013. Correct. So it is beyond 1 year.
Beyond, my lord, the limitation is 3 years, man.
3 years. Okay, then that question.
Yes, ma'am.
Before we were referring to year.
My lord. 3 years, my lord. The rule says. My lord, here.
One more date is important, you said. Which is that?
The date of death, my lord.
Death, you said that. 24/12/2006.
Dates, and my lord, the
date of application, date of attaining majority.
Majority. These 2 dates, my lord. Now, my lord, coming to the application was fairly submitted. The distress certificates were obtained. After that, the matter was kept pending. This present petitioner approached the Honorable Court. Honorable Court directed to consider the case of then it was subjectly rejected, my lord. That is the impugned order. That is on the ground of 2020 rules.
When you mean to say, as on the date you applied, which rules were obtaining?
My rules should be 1990 rules amended in 2016, but I had applied on 2015, so 1990 rules, my lord. My lord, the earlier order of this Honorable Court was identical matters had reached the Honorable Supreme Court, my lord, and they were disposed of, in which government have also have issued a notification that the date of death will be the guiding factor for giving rehabilitation appointment, and for that reasons, each and every application would be revisited, re-verified, and the appointments will so on be given, taking into account the vacancy position.
Very
my lord,
you have filed that
in this case, only I filed an IA.
Is it true? But they will not obey court orders, whether it is Supreme Court or JMFC third court, they will not obey that order.
They have themselves have amended the rule.
Recently, government has amended that the date of death will be taken into consideration.
Because, my lord, the date of death is universal, my lord. That cannot be changed. But the subject to applications, it changes with respect to time, for respect to the documentations. And
200 cases also disposed of by the Honorable Supreme Court.
And I've also
there's subsequent
that Jitalua, we have other day we have also submitted. Jitalua,
yes.
We have submitted and your lordship has passed the order also.
Yes, ma'am.
Do you have
we have given the judgment.
What is fun in passing the orders? When apex court orders are not obeyed, what Dixit will do?
But interestingly, prior to pronouncement of that judgment by the Honorable Apex Court in Jitalua, your lordship has passed while sitting in the division bench exactly that order in forwarding the document.
Also will not be obeyed.
That will be obeyed because on 12/4/2025.
No, my lord, I fairly submit. In this case, in the rehabilitation appointment case, the government have also taken a fair stand, my lord. They have issued a notification by taking they have submitted that.
Considered in
yes,
also. This rejection
and in many of the cases, the procedures are also going on.
This is a case of 2000.
The rejection order passed
rejection is
26 July 2024, my lord.
that is at page
My lord.
52.
And the main ground of rejection, my lord, apart from my lord at friend what submitted, my lord, the collector, he is not the appointing authority, my lord.
But he passed the order.
Past who you only, my lord, they are providing the dispatch certificate.
No, my lord.
The direction is to collector to consider, my lord, the project of the petitioner, my lord.
My lord, the application was made
Actually.
It's the district education officer, my lord.
Anyway, whichever is the competent authority, to him he should forward it. Suppose your friend writes a letter to you.
Like,
He is not your friend, but he mistook your name and it came to you. Are you not going to redirect that letter to your friend, saying that, see, somebody has come to me, please take that. Minimum civilized society will act that way. Of course, government is not civilized, is another thing. There is one famous statement, I do not know, it is ascribed to Harold Lusky, a professor in Manchester University, a famous author of two famous books. One is ABC of Politics, another is Grammar of Politics. He says, society is formed out of goodness of people, and the government is formed out of wickedness of people. But going by what all is happening, it appears to be true now. Could you get that? Read that paragraph just slowly. Put a flap to that page. It becomes easy for me to reproduce it again. Just put a flap there. Yes, read. Youngsters will be seeing your performance. And it's a very good place to marketing your skills. Yes, because I have put it online. Free advertisement. Yes.
Such a contract will not absent the ownership, building, lessors will have to be successful.
Correct. That's the law. Whether any Supreme Court decision is there?
Yes, Your Lordship. There is some Supreme Court decision.
It followed Bombay High Court.
That is AIR 1958, SC page number 17.
AIR 1950, 50 or 58?
58.
58 Supreme SC page
718.
789. Mullah page?
Page 867.
Mullah page 855. 867. Or take that book and keep it in my table. Otherwise, madam may take it with her. There is one saying in Sanskrit. Pustaka vanita vittam paraham gatam. Who said it?
The next line says that what it is gone, that never returns.
It never returns. Gatam. Yes.
My lord.
Yes.
So they have rejected my claim under the new rule that is.
All right, we are allowing this petition.
Yes,
You were saying something.
Lordship, kindly, I may be permitted to place, my lord, rule 9(7). Itself, my lord. Sub-rule 7, my lord. If at the time of death there is a ward who is minor and who was alone is available in the family of the deceased government servant for re-employment, he/she shall apply for job under these rules on attaining the age of 18 years and in no case beyond 3 years from the date of attaining the age of.
So 3 years after attaining the age of
my lord. My assumption is who alone is available, my lord. At the time of death of the that particular problem says, my lord.
It should be 3 years from the date of death.
Then from the date of attaining the
age of majority.
The son is minor. The widow was there. He was eligible. He could have applied.
Does it say so?
Yes.
Yes, madam.
That speaks like this. The word who alone is available.
Who alone is
available. But in these cases, the widow is available by then.
Have you taken up that?
No, that has not been taken.
My lord, in impugned order, there
The rules
not
says
taken a
that.
stand. And my lord, I'll clarify just for a moment, if my lord may permit me. That is what my learned senior is talking about. That is Rule 2B, my lord. And here, my lord, this honorable court have time and again, rehabilitation assistance is a transferable right that cannot be pick and choose, my lord. Here, what has happened, who is eligible, when a family is in distressed condition, a person should come out, apply, and if he is eligible otherwise, will be given appointment in order to eradicate the distressed condition, my lord. So, my lord, here, after going through all this, my lord,
If he is not eligible,
would have filed no objection certificate and medical.
no objection already. No, but is it negotiable? Right is negotiable.
My lord, it's a transferable right. My lord, this honorable court coordinate bench have also held that, my lord.
Where is that?
My lord, I'm not having this because this point was never in the impugned order, my lord. But if my lord may permit me, there's a judgment of this honorable court that it's not a transferable right. And Rule 2B in many of the cases has been struck down, my lord.
To be struck down?
Yes, my lord. Rule 2B, my lord. There are judgments, my lord, which show that Rule 2B will not be applicable, my lord. Any one person can apply.
Yes, sir. What do you say?
It is not Rule 2B. I am placing that rule basing on which he is claiming relief. It is Rule 9, Sub-Rule 7. Sub-Rule 7. If Sub-Rule 7 speaks that.
Kindly read.
Yes. At the time of the death of the government servant, there is a ward who is minor and who alone is available in the family of the deceased government servant. Lordship, I am.
No, understood. Got the point. There is some logic in that.
Alone is because the term who alone is available, my lord. What I mean to say is, at the time of the death, the widow.
If widow was available, then he cannot take benefit of 18 years, etc. Is your contention.
Exactly. She could have applied for a rehabilitation assistance.
What your mother is doing?
My lord, presently, my lord.
Is she qualified?
My lord, qualified. That I have to take instruction.
You take instruction and
family member.
After.
Not a family member.
My lord. Here, my lord, the only condition is that family members will apply, and my lord, rule.
That's a definition of
If you want to take the benefit of relaxation,
my lord,
then you have to show my mother was not entitled to this job because she is uneducated.
Exactly.
Mute, dumb, lame, as the case may be. Otherwise, the logic of that rule will be lost. All right,
my
lord. Or alternatively, I will direct consideration. That may not help you. Reject because that contention they have already put forward.
My lord, by taking this notification, if my lord directs, then that will suffice, my lord. If that is so, because in impugned order, as per MS Gill case, my lord, they cannot take a stand outside of the impugned order, my lord. In the impugned order, they have not taken their stand. They have simply rejected 2020 rules.
It's not applicable. Law. We are placing the law before your lordship.
I am challenging the impugned order. If my lord quashes the impugned order and directs for remittance in accordance with this honorable Supreme Court judgment and the.
Just consider that all people are contentions.
But our objection may kindly be noted.
Correct. Kindly be seated. Petitioner who has suffered rejection of his claim for appointment on compassionate ground, while order dated 26/7/2024, is grieving against the same before the rate court. First, counsel for the petitioner vehemently argues that his father, a PE teacher, having died in harness on 24/12/2006, his client was just a minor. His date of birth being 3/5/1995. And therefore, under the extant rules, he had applied for compassionate appointment on 6/7/2015. Is well within a period of 3 years prescribed under Rule 9(7). Is it 7? 5.
Rule 9(7), my lord.
9(7) of that rehabilitation rules which you have considered today. 9 rules. 1990 rules. 1990 rules. First, that being the position, coupled with the distress certificate issued by the competent authority, the impugned order is liable to be set aside, and the direction appointment be issued. First, he also draws attention of the court to the apex court decision in state of Odisha versus Jita Luha 2025 INSC 813 in support of his contention that the had undertaken before the apex court to revisit all such applications for compassionate appointment in keeping in view the rule position as on the death in harness. First stop. Next paragraph. Learned AGA, Mr. So-and-so and Mr. G oppose the petition, contending that the impugned order cannot be faltered in as much as the invocation of Rule 9(7) is subject to the condition that there was no other candidate entitled to compassionate appointment during the minority of the petitioner herein. Semicolon. It is not the case of petitioner that his mother was not entitled to compassionate appointment, and therefore, even if the mother has given the NOC, there is no warrant for interference of this court. First one. Next paragraph. Having heard the legal parties and having perused the petition papers, no counter is filed in this case. No counter. This court is inclined to grant indulgence in the matter as under and for the following reasons. Number 1, there is no dispute as to the foundational facts, namely, petitioner's father died on 24/12/2006, semicolon. Petitioner, having been born on 3/5/1995, had applied for compassionate appointment on 6/7/2015, which is well within 3 years contemplated under Rule 9(7) of the subject rules, and consistent with the direction of the apex court in Jita Luha, the rules that obtained at the time of death of the breadwinner in harness ought to govern claims of the kind. First stop. The vehement submission of the vehement contention of learned AGAs that nothing is stated in the subject application for compassionate appointment about petitioner's mother's disentitlement, and therefore petitioner is
not entitled to have his case considered on merits for judgment, does not merit examination, does not require deeper examination at the hands of this court, comma, no counter having been filed by the state in that regard. Full stop. That apart, the state itself had undertaken to revisit applications of the kind, as has been reflected in the judgment in China Luha, and therefore that exercise has to be undertaken by the jurisdictional authorities. First up. Last. There is one more lacuna in the impugned order. Semicolon. The district collector is the competent authority to issue distress certificate. Correct? That's. And the person to consider application for compassionate appointment is the appointing authority, comma, which the district collector is not. First, therefore, the impugned order is liable to be voided on the ground of lack of competence as well. First off, next paragraph. In the above circumstances, semicolon, a writ of certiorari issues quashing the impugned rejection order dated 26/7/2024 at Annexure 7, semicolon. Matter is remitted to the portals of who is the competent authority? OP number 4 for consideration of fresh in the light of Jita Luha case Supra, and also the rules obtained when petitioner's father breathed his last. First of all, this exercise has to be undertaken and accomplished within a period of 8 weeks. Yes. Want to say something? Yes.
Well, the notification may also be taken into consideration that I filed in IA the 4th April 2025.
And the notification dated
4th April 2025, Annexure A to the IA.
Annexure
A to the IA,
to the subject application. Okay. If you give that notification number and other things, application annexure, we will not finish. This is available. Dated 4th April 2025. It's here, na?
My lord.
You have he has no, there is no number. Number is there. Notification number
11771.
11771.
Top of the notification.
Top of the notification. It is there. Dated. Okay.
Much grateful.
You argued well. Yes.
Item 38.
But Jana's point, no, I have not seen any such decision. It's a point actually. Otherwise, there will be many other people who are entitled to. And last child will be given to the sent to the appointment, so that for another 30-40 years he can be in the
distress of the family. But go on continuing there.
In this case, I have received the para recommended yesterday. Will file counter within a week.
Which year matter? 38, 37. Now, like 37 is over now. 38 you are calling now. Yes. 38. What is the position, brother? You want to file the objections?
My lord, I have received
counter within 2 weeks. Post after 3 weeks. Next.
Interim order to Interim order to
Interim order is there. Yes. Post after 4 weeks, interim order to continue. Yes.
39 may please, Lordships.
This matter was there yesterday, my lord. Your lordship directed with the government.
My lord, that matter yesterday it was there. My lord, sir, directed by while the interim order of status quo is
Correct. Still he sends the letter.
That
What
I
is going to-
have filed this affidavit, my lord. Let me submit this in.
What is the substance?
Well, the substance of the matter is that the petitioner who has challenged this impugned order before this honorable court with a prayer for regularization of.
No, that's not it. What about the violation?
My lord, it's a segregated, my lord. The post which has been advertisement sought for advertisement, that is for the post of junior assistant through staff selection commission. But the post which my learned friend's client is there, he is a data entry operator and contractual.
That post is not notified.
Exactly. That is all the way separate. At no stage of imagination, this can be treated as one.
ST and ST candidate, not for general candidate.
My lords may kindly see annexure IA by 2 at page number 9. I'll just clarify, my lords.
So now they have clarified. How you are agreeing?
Now file this
application.
Let him take that affidavit and also because it's the very affidavit
How you are concerned with that other post?
is a different cadre.
The same post in the camouflage manner they have done. Your lordship may kindly see. Yes, then.
Lordship says
It is meant for STs.
He is appointment on the contractual basis has been extended by 1 more year. So status quo is maintained.
That he has admitted in his IA number 1 annexer.
My lords may kindly
This is admitted. He can have a glance to the
he is
office.
continuing, he has no problem. No,
My lords may I'll just place one paragraph. Your lordship is clarifying, but your lordship may kindly see one paragraph.
What paragraph? They are
Yes, yes.
that you are not concerned with the post to which the appointment is.
My lord, for the satisfaction, my lord, for page 7 of his own IA, can have a glance for a moment. This has been well extended by the authority.
Yes.
different cadre.
So far this petitioner is concerned, the terms of contractual engagement of the following contractual employees is hereby renewed for a period from 3/3/2025 to 28/2/2026.
I have filed. But your lordship may kindly.
What is your grievance now after this order?
Yes, your lordship. After this, your lordship may kindly turn to page number 10 of my IA minutes. Only for a moment, my lords.
Now what for? Tell me.
Yes, what they have stated, my lords. The plan for in the subject they say filling up of 4 vacant posts of junior assistant as ACDBT Orissa.
You want to argue or you want just?
Yes, your lords.
That's your.
Your lordship is clarifying that. Yes.
Now, we'll clarify that your appointment is continued for 1 more year, and therefore you have no right to charge. This petition has become infirm. So we'll place their assurance on record also.
I have become infirm. My petition is for regularization, your lordship.
For regularization.
Yes, your lordship.
Then you consider for regularization.
No, that is not the way. They have posed that IA particularly, while the order is in operation, that has been blatantly violated by
My friend said that the order is
regularization that should happen.
No, that is pending, my lord. That is the main
that has been rejected. Rejected on the ground. Now it is continued for 1 more year.
Yes. What is the reason?
In the light of that, you have to consider.
That we will consider, but that is a separate aspect altogether.
That he misled is your version.
Kindly see, your lordship, only for my.
Sometimes,
It is miscommunication. It's miscommunication. It's a miscommunication, not misleading.
May I place only, with the kind lordship's kind permission, may I place only one?
You that you will get your application for regularization considered. Number 1. You are continued for 1 more year.
Yes, right.
Therefore, what is the order now rejecting that one? That pales into insignificance.
Yes.
And for other appointments, let them proceed. How can you?
Your lordship may kindly see only one paragraph, your lordship. Where there's in the top, in the subject they say, only for a moment, for my satisfaction, my lordship. In the subject they say, filling up of 4 posts of vacant post of junior assistant. Yes. But in the paragraph they say, at page number 10 they say, the plan for examination for the post of junior assistant of ACTVT Orissa or similar other posts.
And we'll say similar other posts.
Similar other cannot be. Yes, close down the junior assistant. It is at par.
Similar other posts means with the existing generis. Yes, there is a rule. Do you know?
rule of existing generis. The genus governs the species. Suppose if I tell you, you go to market, bring tomato, okay, chili, and coriander, etc. You will bring what? You will bring other such vegetables, say category. You can't bring a tracking. Is it not? You bring, because I have said ATC, etc. That rule, in that way you have to understand that. Anyway, we are making it clear now. You should be happy with that.
Still you want to argue? No. Your Lordship may dispose
We
of...
dismiss your petition.
No. Your Lordship may dispose of my IA so far the main prayer is concerned. And
No. Absolutely, there is no case.
IA needs to be dismissed.
The petitioner essentially is seeking regularization of his service.
Data entry operator.
As a data entry operator, his application having been negatived by OP number 3 by the order dated 31/5/2023 at an extra 19. First. Next paragraph. Learned counsel for the petitioner argues that a coordinate bench of this court was order dated.
This is order dated, my lord. 1/5/2025.
Had directed maintenance of status quo and despite that, OP number one had undertaken to go for recruitment process in blatant violation of the said order, and therefore some action should be taken against the violator. First, an application is moved in this regard, supported by an affidavit. First term. Learned AGA appearing for the official OPs and learned advocates appearing for the private respondent.
OP number 3.
Oppose the application and the petition, contending that the recruitment process for is being undertaken in terms of letter dated
6/5/2025.
6/5/2025, and that in no way affects the claim of the petitioner, and therefore application is liable to be rejected with cause. First now, there is a largely acceptable position as has been projected by the learned ADA and other OPs. First, therefore, application of the petitioner is rejected. Next paragraph. Learned counsel for the petitioner notifies to the court that the tenure of his claim is extended by 1 more year by virtue of order dated
30/5/2025.
30 May 2025, and therefore impugned order now paling into insignificance. A fresh decision has to be taken as to his claim for regularization. Yes, that should be the way now. Otherwise, it will be a problem to you.
But since in the main petition, let them file their counter. It's already covered by your lordship's order, my lord. It's already covered by your lordship. Your lordship may kindly see your lordship's order, my lord.
Petitioner places reliance on the order of this court, on the decision of this court, in so and so in support of his claim. First, this matter need not be deeply examined because of the fair stand taken up by learned DGA that in view of extension, there would be no difficulty for considering case of the petitioner for regularization in due course. First, next paragraph. In the above circumstances, petition is disposed of.
But the impugned order may be caused, at least.
It pales into insignificance. You have said, I will not question that.
Keeping
in first two cases, first two cases, my lord, I am appearing for OP number 3.
But all these same matters.
The same matter.
Similar matters.
Four matters are there, sub-item.
The only thing is that order rejecting that this one, those dates differ.
No, same date.
Same. All same.
Only the IN numbers will be different.
IS will be different. But makes no difference. So you can say IS.
And we have filed this affidavit in the first case, my lord. That may be taken care of in now.
On behalf of OP number 1, he's taken on record. One sentence you have to add.
That's keeping into the judgment in Jacko and Shripad.
I also support this.
Taking into consideration the order passed by the Honorable Supreme Court in Jacko and Shripad.
Let us see. They have taken the fair stand. Yes, next.
So our names may kindly be reflected for the OP so that
give your
list. In the list.
Which respondent who appears? Give the list.
In OP number 3 in the list also names are
write down it. Our
Item 40, cause list
Item 40.
yes.
Sorry.
That's no problem. Edition generis was treated by the apex court in University of Madras versus Shantabai while treating Article 12. He is a state or not, which it held it is not at that time. Like this judgment, it is
not coming within the Article 12. That
is this one. Would be college matter from our state it was. That came to be reversed by the apex court in Ujjambai versus state of UP.
Subsequently also that Saint Mary and others, yes, are in
Ujjambai. It said the university is an instrumentality of the state. Yes.
Item 40.
40. What is this matter about? If it's not removed, my lord. But this is the latest matter, na? 25 matter. That was a 2015 matter. I dismissed it for non-prosecution. But this, how can I? I'll give you a short break. There were 2 weeks for removal of the defects pointed out by the registry. My lord. Which petition is likely to be dismissed on the next date of hearing. First up.
Item 41.
Your Lordship, I'm appearing in item number 41 for the petitioners.
Yes.
Your Lordship, I'm seeking some time to cure the defects.
Yeah. Defects not removed.
No, Your Lordship, I'm seeking 2 weeks time to cure the defects.
All right. What's your...
Sorry, Your Lordship?
What's your name?
Your Lordship, Advocate Gauri Rajput.
All right. Advocate Gauri seeks 2 weeks for compliance with the office objections.
Full stop. Granted.
Grateful, Your Lordship.
Finally.
Item 42.
Yeah. 42. Same order. Next.
Item 43.
Same order. 43, 44.
Before my lords, on behalf of Mr. Samuel, he has requested me to make a prayer before lordship for withdrawal of the writ petition, my lord.
To withdraw?
My lords.
All right. Counsel for the petitioner seeks leave of the court to withdraw the petition with liberty to approach the court afresh if needed. First, petition is disposed of accordingly. Yes.
Item 45.
A memo to that effect is filed. Petition is disposed of accordingly. 45. 2 weeks for removal of defects. Final. Next time, failing which petition may be dismissed next date. That way. 46.
46 also I pray for 2 weeks time.
Same order.
Defects are pointed about the registry.
47.
47.
Same order.
48.
48. To withdraw to liberty.
That same order. Withdraw with liberty. Memory itself. Next. 49.
Item 49.
My lord, the requisite were directed to be filed within a period of 3 days. I filed it on the 6th day, my lord. That may be pardoned, my lord.
Requisites filed belatedly be processed immediately. Okay.
My lord, there was an interim order.
Interim order to continue.
My lord, directions were sought for, they were directed to sort instructions from the...
All right, anyway, will you continue the interim order?
My lord, paragraph 2 may be seen, just that last, my lord. 7, order number 4.
I have received the paragraph comment, my lord.
But where is the compliance? 2 orders, 11.7 and 29.7.
My lord, even this order I have produced before them.
They are not compliant. What was the order?
My lord,
compliance.
My lord, the first order was that the post may not be filled up. Subsequently, they have issued an advertisement for that post. The second interim order was that he may be allowed to continue. He has not been allowed to continue.
Why, brother?
Next week, my lord, I will.
Initially, they said that you produce a certified copy of the order. That also we have done. Still, they are not complying, my lord.
They needed something more, perhaps.
My lord, that may be the case. That may be the case, my lord.
Learned counsel draws attention of the court to the interim orders dated 11/7/2025, 2025, and the other order dated 7/8/2025. First off, he complains that the directions of 11/7/25 and 29/7/2025 have not been complied with despite request, and that there is no possibility of their compliance unless some punitive action is taken against the violators. First off, learned is time to report compliance. You have to report compliance. Report compliance. Call this matter next week. Yes, next week. Yes. At least he should be taken to the job in question. When there is an order, you should obey the orders. And you should get the goodwill of the court. That comes, that's an investment where you can make use of in bad cases, where you will be in difficulty. Yes.
Lordship, item number 50, I pray tomorrow, your lordship. Your lordship, it is old case. I should not adjourn. Maybe taken up tomorrow, your lordship. He has some difficulty. Both cases.
All right, call tomorrow. Oblige the request of. Item 51. Kamal Lochan. So many advocates are there. Nobody is appearing. Huh? Come slowly. You may not injure the other sitters there.
I'm sorry, Your Lordship. I'm sorry, Your Lordship.
Yes. You want to take rest for 2 minutes? Not necessary.
Lordship, Your Lordship, kindly see Annex 29, Annex 4, page 29. Elaine, the petitioner applied for the post of Shiksha Sahayak during 2014 and 15.
Shiksha Sahayak.
Lordship. Lordship, Para 2, clause 3. The candidate shall give option for at least 5 districts according to the priority. Para 2, subclause 3.
Para 2, subclause 3.
Lordship, page 29.
The candidate shall give 5 districts according to priority.
And accordingly,
totally how many districts in Orissa?
30 districts.
30 districts.
And accordingly, Your Lordship, page 32, Annex 5, I have applied for 5 districts. First preference is Kenduchor district.
Now what they have done? They have given the 6th district.
Your Lordship, for 5th district, I have Baleswar, I have given the 5th preference. I have given the 5th preference. Accordingly, they called for me for the verification, and I appeared in the verification. My specific contention before this Honorable Court that the person, those who have never appeared in for the verification, they give an appointment. But whereas I was appeared before the verification committee, and I have never given the appointment order, Your Lordship. Paragraph 10 and 11 of my writ petition.
Why, brother?
For that, Your Lordship, for that is Your Lordship.
Such things happen.
Somewhere yes, and I should not say no. But so far this instant case, this is an option which has been exercised by the candidates, those who have applied for the post of Shiksha. But this is the 5th round, and this is meant for so far this reservation is concerned, he belongs to SCBC category. And the 5th round comes under the Baleswar district, that we have given the details so far this counter is concerned.
Lordship, but Your Lordship, kindly see the order. They are in 2023 passed by this
15 to 23.
23 order number 10, Your Lordship.
Order number 10.
10, Your Lordship.
What it says?
It is submitted by Mr. Pikeratho Learned Counsel for the petitioner that as per notification dated 34/2016, the 5th preference candidate were required to appear physically on 5/5/2016 at DPO SSA, Baleswar during with all original certificate. It is further allegation that only 8 candidates appear on the date fixed, among whom the serial number 4. In view of the marks obtained by him in paragraph 10 and 11 to the writ petition, his fact has been stated that, but not replied to specifically in the counter affidavit. And till date, they have not obtained any instruction, Your Lordship.
Even selected candidates also have not joined.
They may join in another, though the petitioner, the candidate has to appear for the
advertisement of 2014, modified in 2016. So, have joined because due to non-availability, and so far the preference is concerned under the particular district, and the order which is at 8/8/2024, thereafter also we have filed this affidavit.
Now, can you accommodate him or not?
That I have.
He is a member belonging to scheduled caste.
No, SCBC.
SCBC means
SCBC.
Socially, educationally
backward.
Economically backward.
EWC.
Exactly.
Socially and economically backward communities.
Classes.
CBC. What are you going to do?
The availability that have because
So
in the
assert,
meantime,
come back. If there is any vacancy, just accommodate
in that particular category, my lord.
Very well.
That may be reflected that I because so far this present position is concerned to that effect there is no vacancy. That I have given in an affidavit. In addition,
Anyway, somewhere you have to accommodate them. He is eligible. He has scored more actually.
But the
We'll call this matter next week.
10 days, my lord, give me because I have
this matter on after 10 days, some date. After 2 weeks, yes. So a certain vacancy position into which case of the petitioner
under the
may be considered under. Okay.
Item 52.
My lord, item 52 on behalf of Mr. Bahali. My lord, he is in difficulty, so let it come next week.
Next week, not possible. To 17 matter actually. After 2 weeks. Reluctantly adjourned by 2 weeks on request. Yes.
Item 53.
My lord, the husband of the petitioner, she had made an application for her appointment under Rehabilitation Assistance Scheme. That has been rejected.
On what ground it is rejected?
That was rejected on the ground that she had not secured the points as per the guidelines promulgated in the year 2020, my lord.
2020.
2020 rules.
Yeah.
2020 rules, my lord. The only ground basing upon which my application for appointment was rejected.
Where is that impugned order?
That is, the impugned order is under annexure 4, my lord. And it was 13 to 14, my lord. Your lordship kindly peruse page 14. 14, my lord. Running page 14. Last line, my lord. Since the total points allotted to the applicant 60 in part 1 and part 2, the applicant shall automatically ineligible for the appointment under rehabilitation assistance.
What is your bank deposit?
18.6. My lord?
Bank deposit.
That I'm sorry, my lord, that I don't know.
You are having a lot of bank deposit and still you want a job also.
No, I don't have. Had it been so, my lord, I would not have made an application for appointment under rehabilitation assistance scheme, my lord.
This is not compassionate appointment.
This is compassionate appointment.
He died in harness.
Yes, my lord.
Who died?
My husband died.
Your husband died?
My husband died while in service.
How many years of service he had put in?
That is...
Knowledge. What is the pension you are trying now?
Is that 9.6?
You are having a house pension, you are owning house also.
That I have. But my lord, so far as...
What's your objection? Counter.
My lord, here we have not filed the counter. So far the 2020 rule is concerned. So under that particular format and the mark which has been awarded to the person concerned, those who have applied under the RS scheme, under that my learned friend's client is not coming.
No, he is not coming. That
my lord, today morning that has been amended by guidelines 2025. I have to study, comparative study between the guidelines 2020 and 2025 and 90.
And by the time you complete your study, your client should survive.
Let it come tomorrow, my lord. Tomorrow.
Call next week at the request of counsel for petitioner. Week after next. Yes.
Next week, my lord.
Let's see.
Okay. Item 55.
If I the lordship.
Let's go. So far the 55 item which has been allotted to me, in that particular order, I was the arguing counsel.
Where's the
So
arguing
it may be tomorrow, my other, I should not.
The only problem is, here is a case my lord knows also. They were appointed, pursuant to selection, pursuant to an advertisement, they selected, got appointment.
Who Mr. Jena can appear. na?
G can.
Yeah, G can appear. Yes. You extemper. You have that capacity.
Very short point, man. Very short point.
We all are here.
After the issue is, after appointment, process of selection gets over. After the process of selection is over, can you change the modalities of recruitment? That's the point. After appointment. After appointment, how can you change the modalities of recruitment and terminate us?
After appointment, they have terminated.
Yes, sir.
Yes, after appointment, change the modality of recruitment and terminated us. Two judgments are clear. Process, another judgment. Two judgments are clear.
Sir, 31/12/21 advertisement was issued.
Give the date of it. Can we take this back tomorrow? You want?
Tomorrow.
Call this matter tomorrow. Yes.
That is the inconvenience.
Yeah, to Mr. G, just look in.
But this is a sweet point, my learned friend should take note.
Sir, I am appearing in item 5.
Learned senior is also appearing in the other same matter.
Sir, tomorrow we will have it.
My lord.
Yeah, please come tomorrow.
My lord.
Yes.
Item 56.
Wait, please.
My lords, I am a registered organization.
You are?
I am a registered organization who's got permission to run a childcare institution in Orissa, my lords. What has happened is I got a license for a period of 5 years, which was renewable every 5 years.
Every 5 years.
Every 5 years it was renewable. Now what has
that license is issued under which law?
It's issued under the Juvenile Justice Act, my lords.
Juvenile Justice
Yes,
Act.
my lord. Orissa Act also under the Orissa Juvenile Justice rules. Also it has been that permission is given to us. After we fulfill certain criteria, that permission is given to us. Now in that permission, what happens is some factors, some aspects like the rent or some other miscellaneous expenses are given through a grant in aid, which is released by the Union of India in favor of the state government. We raise the bill and they are supposed to pay us that amount. What they have done is from 2016 to 19, they did not pay us that amount. So we continuously wrote letters to them. In the meantime, when letters were written to them, on his own accord had written that you should because you're not paying us the grant in aid. So we closed the institution because we cannot carry out the operations any further. But thereafter, our governing body wrote another letter saying that the secretary did not have the power, so he could not have written that.
When secretary wrote and when governing body wrote?
My lords, yes.
And what action you took against the secretary?
We have terminated him, my lords.
You have terminated?
Yes, we have terminated.
When he wrote?
I'm just giving the details. It's 8/7/2020. He wrote a letter, and thereafter we wrote the subsequent letter withdrawing it. Sorry, my lords, the date is 26/5/2020, the secretary wrote. 26 May 2020.
Not 8/7/20.
No, my lords, 26 May 2020. Thereafter, governing body wrote a letter.
Governing body wrote on
8/7/2020.
When he was terminated.
My lords, thereafter what happened was...
No, when he was terminated.
He was immediately terminated. In that letter itself, we said that we have terminated him.
Where is that letter?
I'll show my.
No, you have mentioned it in this letter, but where is the termination letter?
The termination letter is not on record, but we have terminated him. We have stated in a letter, in that letter informing the opposite party number 4 that we have terminated him. He did not have the power and we terminated him.
Yes.
Thereafter, what happened, my lords? We continued with the children that was allotted to us by the board.
When you wrote that secretary's letter is wrong.
Yes, my lords.
And unauthorized.
Yes, my lord.
What was the response?
They did not give any response. It just continued as it was. They did not give any response to it.
Yes.
Thereafter, my lords, what happened was.
Who is your opponent?
My lords, the Orissa state, the Union of India is, because the first party is Union of India.
Union of India will not come to Orissa.
My lords, because they are the ones who release the funds that is supposed to be released to us. That is the reason.
But you have to bring him.
My informed actually was going to take time today. That's what I was informed.
Well, generally, from Union side, nobody appears.
I was informed this. That's the reason why I was waiting for them, but as it did not come, so. But I was informed that they are going to take time.
The council appearing for Union of India is absent. Absent. First off. To give one more opportunity, call this matter after 2 weeks.
My lords are going to fix a date.
Huh?
My lords are going to fix a date.
So after 2 weeks, it will come. Come away memo.
Obliged.
Just reminding, refreshing my memory.
Obliged.
Item 57.
57, my lord, here prayer of the petitioner for regularization, they are continuing as a contractual. While they are continuing since 2018-17, all persons are there. Advertisement was published, we challenge the advertisement. And similar matter, the same advertisement is on posted before the Honorable Appeals Court, where this Honorable directed for regularization. So that is pending, that is coming on the 26th matter before the Supreme Court.
Before the Supreme Court. Very same advertisement.
Same advertisement. 12
But we can decide this, that this order can be placed at the hands of the FX court. Why to keep this matter pending?
No, where similar matter, my lord, some coordinate bench dispose of consider the case of the the judgment passed by this Honorable Court.
Yeah. That matter went in.
I am for the open number OUTR for.
How do you know?
Huh? May I kindly be taken up after 26?
After 26. So that what will happen in Supreme Court will be known to us.
Oh, yeah, man.
This matter, when will you call this? In the first week of September?
Yes, madam.
In the first week of September. As requested.
Interim
order to continue.
First week.
Or second week.
Second week, madam.
Second week of September. Interim order to continue.
59.
58. Pardon to make a mention, your lordship.
58 is pardon to pay. Somebody took time.
Mention, your lordship.
The petition, sir. 58.
I am. Your lordship, my senior had informed at 2 p.m. that we were not informed and an adjournment was taken.
Yes.
And the matter was posted today as a last chance, your lord.
But who took time?
Your lordship, maybe the OP number 3, your lordship. We are for OP number 4, and my learned senior had mentioned, your lordship, at 2 o'clock, your lordship, that without informing us.
Call this matter tomorrow.
Your lordship.
Call this matter tomorrow. Or a day after tomorrow.
Your lordship, as your lordship.
That's it. So order is not signed. Not signed. Or call it the day after tomorrow. Yes.
Item 59.
Please,
my 59. I am a teacher pursuant to the order passed by this Honorable Court, Division Bench, as well as the Honorable Single Judge. And I am continuing in that post, and only my miscase is that direction was given to the opposite party number 5, block education officer, to release my salary. Though I am also receiving my salary. For in the meantime, he has also, for no reason, he has also stopped my salary.
Why? He wants a share in your salary.
Sir,
Does he want a share in your salary?
My lord's pleadings over. The lordship may hear the matter.
Argue. But that's the case. He has argued now. No, you have to tell.
The merit there. Merit I can argue. Only thing is, sir, my mistake.
Is he your employee or not?
Yes.
My lords, he was terminated from service.
When it was terminated?
Termination order has been quashed, sir.
When he was terminated, when that order was quashed?
My lords, it is Annexer 8, 7/5/2024.
7/5/24, who was terminated?
My lord.
By whom?
By the education officer.
Is he appointing authority?
Yes.
Prosecution, he has power to terminate also.
Yes, ma'am.
Which is that power? Which section?
My lords, there was a disciplinary proceeding against him. He had given forged fake certificates at the initial stage of appointment. Action was taken, but the Honorable Court was the termination order on the ground of not following natural justice.
No, that
to afford opportunity of hearing and action.
Was in this is the DE was held. No DE was held. Simply dismissed.
No, disciplinary proceeding
was held. But why the court
well, it's after that. Again, de novo inquiry was that and
7/5/24 terminated.
My lords. And this order also applicable, my lords.
1 second. No, that was set aside, na?
Yes. This order was not set aside.
Earlier one was set aside.
Mine.
The earlier one was when terminated. Which is that WP number?
Sir, WPC number that is 8931 of 20.
Decided on?
15/2/2023. And the said order has been also set aside without giving reasonable opportunity to me. They have terminated my...
Termination order was dated?
Sir, termination order was dated 20th/6/2000.
Question.
Sir, that order has been because the Honorable Division Bench in writ appeal also preferred by the state. The Honorable Division pursued earlier also the Honorable Single Judge directed the termination order quashed. Then they have not given me my salary, not given me re-engagement. Then Division Bench also ordered the preferring the
is there order for reinstatement?
Yes, that is there, sir.
My lords, kindly come to Annexure 9. That is the order passed in the writ appeal, my lords.
What it says?
My lords, the
upheld order of the noted single judge.
My lords, sir. And my lords, last para 6. We do not find any legal infirmity in the impugned order passed by the learned single judge. Now, since the order passed by the single judge pursuant to a subsequent order passed in this bench has been given, and an order has been passed on 7/5/2024 by the block education officer.
That order you are not changing.
Against that order, again the matter also again a report to the Honorable Single Judge. Honorable Single Judge set aside that order. Sir.
7/5/24 order.
Sir.
What happened to 7/5/24 order?
The order passed on, sir, 15/2/2023.
That is set aside.
In that order, that order has been set aside. The order passed by the block education officer, the appellate authority order has been set aside and allow me to reinstate. And I was also continuing in the post and getting my salary. Without any reason, they have stopped my salary.
No, now the 7/5/2024 order you have been terminated.
Terminated. Thereafter, that order has already been set aside by the Honorable Single Judge.
Where is that WP?
Sir, that is order number 15, date 15/2/2023, sir.
7/5/24 order can...
No, sorry.
No.
Sir, sorry.
Advance bail we can understand.
No, that is no, sir, sorry. 10/7/2024, sir.
10/7/24.
Continuing service 10/7/2024, WPC number 16270 of 24.
Slowly.
The present rate petition.
1 second. WP number.
Present rate 16270 of 24. The order has been passed on 10/7/2024. Whereas the termination order passed by the block education officer has been set aside and allow me to join. That order is available, sir. That is it.
Where is that order? 10/7 order.
Yes, 10/7/24.
WPC
number, the present rate. WPC number, sir, 16270 of 24.
Now, why are you here again? After quashment.
After the order passed by the Honorable Single Judge and also the revision was also directed to complete the inquiry. The inquiry also conducted, completed. They have terminated my service. Again, I moved to the Honorable Division Bench. Honorable Division Bench directed me to approach the Honorable Single Judge. Then I approached the Honorable Single Judge. Honorable Single Judge also held the same view. Again, set aside this order.
Read, setting aside order.
Sir.
10/7/24.
Yes, 10/7.
It only stays the impugned order.
Sir, 10/7 in WPC number 16270 of 24, the order passed by the block education officer has been set aside and also directed to release my salary.
Where is that?
Sir, just to see.
10/7/24 order.
Yes. 10/7/24.
There shall be stay of the impugned. That's all. Again, one more order. 14/8/24.
Sir.
16270 of 2024.
Sir. 16270 of the present rate petition. The present rate petition.
Correct.
The application challenging the order passed on 7/5/2024, order number 600 by the block education officer Kuri, praying to quash the same and confirm the order passed on 15/2/2023 in WPC number 8931 of 20. Please to set aside the same order and on 8/2/2022. In that way, the order has been.
There is no comma, perhaps no speed breakers at all in your language. No comma, no semicolon.
Sir, can you take care of day after tomorrow, sir? Order. The order passed in that is
next week.
16270 of sir 24. Passed by the Honorable Single Judge.
Right. Only in this only time is spent. But call next week.
Sir.
Get the request on.
Item 60.
You prepare a note sheet.
Sir, I prepare only.
Yes, fine.
This is my lord, the employees of institution. They only came before this honorable court with regard to the quantum of block grants they are to get. But it has been given from an arbitrary dates. We are to get the benefit of the block grant of 40% from 2008, 1/10/2018.
Objections, counter is filed.
Yes, counter.
Filed, I have filed. Ready?
Yes,
Start.
Fine. The become eligible to receive this block grant. There is a new under the provisions.
What is your grievance here?
Grievance here only the quantum. Okay, but we have been brought into the fold of block grant. What it has been given to us is from we are eligible by 1/10/2018.
1/10/2018.
We have to get 60% of that quantum because 1/10/15 we have paid 40%. That is the requirement of law. The enhancement is after 3 years. That is there circular. So from 1/10/2018 we have to get 60%. And thereafter 2 years after 100%. What it is done is exactly from an arbitrary date it has been given, that is from 21/5/19. That is the school instead of
2020 number of candidates.
That also that is I have gone amended. They have relaxed it.
Was there such requirement?
Yes, that was a requirement in the original, the clause 6D. That has been relaxed in a subsequent government order under Annexure 3.
Annexure 3?
Yes, 1.3.14. My lord will get it at relevant is, my lord, page 24, clause 2. But they've stipulated two things, my lord. Minimum people strength should be 30 in respect of non-scheduled area and 20 for scheduled area. Scheduled area has been defined in the statute.
Your school is in scheduled area?
No, non-scheduled area, non-scheduled area. So each class should be 30. We have that. But the next clause D says, for enter into the fold of this granted, you should have minimum 30 strength. In present, you should present 30 students. What is the minimum requirement in the HSC examination, with the board examination? That clause has been relaxed in that clause 2. Saying, my lord, that
only new recognized private high schools eligible up to 31 people relaxation of.
May show that provision, my lord.
Following minimum number of students in each class may be 30 in non-scheduled areas, 20 in scheduled areas.
Yes, they only stick to this. The clause D, my lord, will kindly see what is the bottleneck here. Page 18 may kindly see the original line. Page 18. Clause 6D. That is part of Annexure 1.
That no granting
to education features held to present candidate less than the minimum
from clause 3 of section 11 of the Act in respect of high schools signed for different courses and for different year by government.
Well, that 11 says, just I've quoted that provision also, I'm just reading out from the statute.
Yes, so what is your answer?
11.3, my lord, section 11.3.
11.3, yes. That is at page 152 of the book.
This is Odisha Education Act 1969.
Is 152, my lord.
152.
Pupil strength.
152. Pupil strength.
Yes. 3. In case of high schools.
This is high school.
Roll strength each standard class
shall be 30, which shall be 20 if the school
in scheduled areas. Non-scheduled areas, it has to be 30.
We have that. They have given it.
They don't fulfill that.
No. We have fulfilled that from their counter also. One document problem my friend. Page 38 may kindly see from the counter. Internal page 8.
How many students we have?
More than 30 in each class. We have admitted students. That is, they have given it, not I am giving. What the was we are facing, all the students could not be presented in the board examination because they are a test examination. They have to, some people they could not qualify to appear the board examination. That is, they are the dropouts. So that is the reason for which that clause 6D of the main provision was said that even you have to present that 30 strength in the board examination, which has been given a relaxation in that 2004, that notification I have shown to my lord.
No, the section itself says this is Act.
Which one?
This requirement.
Yes, ma'am.
Is of the Act.
No, it's
statutory requirement.
Statutory requirement, you should admit 30 students in each class, minimum.
Suppose if you admit 30 students, next day all they give.
No. We have 30 students. There is no dispute over that.
30 students means,
yes,
30 students appearing for the examination.
No, my lord, that is not there in the statute. That is the only.
That you have to read that way.
No,
otherwise consequence will be, you will admit 30 students, all of them will go away for rearing the cow.
That is not the what they have stated. Kindly see, my lord. Kindly see the facts, because we should not dispute over the facts, my lord. They have admitted.
We will interpret that section.
No,
that thing. Otherwise, tomorrow the government treasury will be empty.
Requirement. No, my lord, kindly see.
Read that requirement. For any question or the.
They have, now the government has given the relaxation. I want the advantage. He says, that is why I am to sue.
Where is the relaxation?
Yes, kindly see.
That should be by statutory amendment, not by GO.
This is also a GO from which, my lord, this granted was paid. Kindly turn to price 16, my lord, first. Let us clarify the facts, my lord. Annexure 1. This is a government order, 10/6/2013.
This order is made under which section?
This is under section 7C4.
7C
With regard to
gives
pay-
power to relax.
No. With regard to payment of gratuity, that is the power.
Let us see 7C.
Yes.
Otherwise, so one day you will admit them and next day you will send them back.
No, that is.
My lord,
kindly see 7.
Okay.
7C, my lord, pays 137 of that book.
Grant the state government shall.
The state government
The
shall,
limits of
within the
economic
limits of the
capacity,
economic capacity, set apart sum of money annually, being given to the graduate of the private education institution of the state.
institutions in the state.
Yes. Now 7C4 is the provision.
State ending, anything but in the room.
Executive order, judgment, decree, so and so
be paid.
so.
And no payment towards salary costs for
Post-person
shall be
income
paid.
for
That's an overriding provision.
Yes.
No, that's going to
94.
help you.
This is the rule making power, not help me.
Huh?
This is the rule making power. This 7C4 is the power with the government to prepare a granted order. Shall I read loudly, madam?
Made under this all.
Yes, this is the rule making power. So, in fact, the government has formulated a rule first. This order, granted order 1994. Initially, it was there. After this amendment, that was repealed.
1 second. This order cannot override the requirement of, which is that
11.3.
11.3.
Yes, I will come to that, madam. Kindly. I'm just clarifying this. This is the rule making power. Under this 7C4, my lord, Annexure 1 was prepared. This order was.
It's only a delegated legislation.
Yes.
It cannot override the parent statute. Do you agree with that?
Yes, definitely. How could it be?
Yeah.
My lord. Now see, this order, how it will be paid, what is the provision, what are the procedure, everything is prescribed here. Now, this has come into force from 1st April 2013.
Yes.
So now kindly come to that clause 5. This is the quantum of granted. How the payment is to be made? 8 years after 100%. The first initially, my lord.
Provided 11.3 is complied with.
Yes, I will come to that 11.3, my lord.
It's not that.
I am not in a hurry.
So,
I will come to that. Well, kindly let us clarify on the facts. That is why I am just bringing, my lord. So what if it in clause 5, my lord, what is stated there? On coming into the fold of block grant, you will get 40%, thereafter 60%, thereafter 100%.
correct.
That is the years. That is there. Now kindly come to 6. That is the bono contention in this case. 6. Sanction of granted all category of institutions shall be subject to the following stipulation.
Namely,
my lord, kindly see C and D will go. For C, no granted shall be payable to an institution which has not achieved such minimum enrollment as prescribed under clause 3 of the section 11 of the Act in respect of the high schools and for different courses and for different areas as prescribed by the government. This is first. We qualify. D, this is the bottleneck. No granted shall be payable to an educational institution which has failed to present candidates less than such age prescribed under clause 3 of section 11 of the Act in the annual HSC examination conducted by the Board of Secondary Education. This is the point, madam.
Correct.
Now, my lord, probably it is going in on my lord's mind. 11.3. 11.3 says if you are having an institution, then you should have minimum 30 students in each class. Minimum.
30 students means, suppose I am asking you a question now. Again.
Yes.
It means 6D. 6D.
No, madam. I'll say 11.3. 6C. 6C. No, that too. What my lord will interpret that is something. But what the statute says
C. That will be very.
That is C, my lord. C. Probably that will be C.
We have to read the fiscal. It's a part of fiscal legislation. Because what it drills a hole in the exchequer.
Yes.
Of the state.
Yes, madam. What they have done,
In order to get the money, what you will do is you will admit to 1,000 students today. Next week, all of them will quit.
yes,
And you will pay them a few rupees even for quitting. Because you will get big purse from the state. Therefore, interpretation of fiscal legislations have to be in such a way that scope for its abuse.
correct, madam. Now, my lord, what they have done, this 2013 order was further modified, or I can say amended in that way, at Annexure 3. That is on 1/3/2014. There, the relaxation the government has given.
1/3/2014.
Annexure 3. Release of grantee to the private education institution, Grant Order 2013. With reference to this Annexure 1, this has been issued. The Odisha Education Payment of School, Upper Primary School, ME Schools, Sanskrit Tools, Madrasa, Order 2013 came into force from 1/4/2013. It has come to the notice of the government that some notified high schools are not fulfilling the eligibility criteria to receive grant in aid as per the provision of the Grant Order 2013. Besides, new privately managed recognized high schools are deprived of getting grant in aid due to non-fulfillment of the eligibility criteria as per the provisions of the Grant Order 2013. Considering the hardship faced by the affected schools, government, after careful consideration, has been decided, 1, to release grant in aid salary of the notified high schools other than 110 girls high school category of the grant in aid for 1 year in relaxation of para 6C, D, E of the Odisha Education Payment of Granted Order, High Schools, Upper Primary School, ME Schools, so-and-so Order 2013. This is Annexure 1. However, the school under the category 110 girls high school may be provided with the granted equal to the amount what they were receiving before the implementation of the Grant Order 2013. Now 2. To extend the granted to the new recognized private high school eligible up to 31/3/2013 in relaxation of the criteria under para 6C, D, E of the Odisha Education Payment of Granted Order, High Schools, Semi Schools, Order so-and-so 2016. This is for me, madam. Minimum number of students in each classes may be 30 in non-scheduled area and 20 in the scheduled area. Relaxation of the criteria regarding infrastructure for the year 13-14 and 14-15 is not beyond 31/3/2015.
No,
so now
not applicable to you.
This is only applicable. What happened, my lord? Just
C is not applicable to you.
Which one, my lord?
You are on A.
A. I am on A.
Number of students.
Yes. What happened, my lord? On honor, if my lord now read with that page 18 again. There are 3 conditions: C, D, and E. We are not concerned more about E. Only similar C and D, these are the 2 clauses. 1 clause says that minimum you should have 30 people. D says you should have presented that 30 number of students in the board examination. That was the stipulation, 2 stipulations, C and D. Now they have made it only 1. Minimum number of students in each class may be 30. The presentation of students in the board examination is not there. So now they are insisting upon you should present the students. That is the point, madam. My case is that in the original order that has been modified here only to meet the hardship.
At the time
the government has done.
At the time of admission, how many students were?
They have given it.
How many of them went to
exam? Kindly see page 8. They have given it. This is the document by the state. Page 8 of the counter.
Yes, brother.
Annexure A by 3.
How many?
Yes, kindly see, my lord. Current document, this is institution. Year 2015-16. These are 3 class high school. Class 8, 9, 10, 35, 45, 41. 2016, 43, 34, 30, 45. 17, 43, 40, 34. 18, 36, 35, 40. So for the presentation of students is concerned, this is in the right hand column. Though in the class 10, there are 41 students in 2015-16. 32 students have appeared the examination. That is 100% result. Now, the next year, though 45 students were there, 39 were presented, 39 have passed, that is 100%. Now, only in 2017, it is 13 and 13. 34 students were there, it was 13 appeared and 13 passed. This is also 100%. And 40, 30 and 27 have passed, 3% fell, 90% resumed. So now my response submission is, what they have done is that Annexure 4 is 1 year relaxation they have given. That 1 year relaxation is this clause 2017-18. We have to get the benefit of 1 year relaxation as per clause 1. And moreover, students is always 30. Even after this admission was above 30. And except this particular year 17-18, my lord, others also it was 30. Presentation of student. So we qualify. It is their document, they are filing. It is on record. Well, I got my point.
I got your point, but I'm not agreeable with that.
No, agreeable by only since Annexure 4, the relaxation. Because they say, again, if my lord will see,
actually only 13 students.
say good, that is why they have said 1 year relaxation should be there. Only 1 year because.
What is the reason for this fall?
Maybe on that, I have no direct instruction on this issue, my lord, but maybe on that particular base, the students required, 4 students, only that much, my lord. If my lord want that, I can ask them what is the actual exact reason for that.
Otherwise, I'm just thinking, you have to interpret the law. Lord Denning said in one matter that judges should interpret law in such a way that it would not give scope for mischief at all. It is a different mischief rule, not mischief, potential mischief rule.
But here, my lord, there is no mischief at all because the government has taken the hardship.
No, it's not that in that sense, in English legal sense.
Yes.
Not mischief of a teacher telling it to the student. This is a jurisprudential mischief.
Well,
let us see.
Well,
heard in some of them. Call first week of September. Let us see. Any judgment of
yes, 2 judgment of our own High Court Pune judgment.
They are that way.
Yes, on this quantum they have decided. I have this.
Have they interpreted?
No, this part, what my lord is raising that point, that was not in it. But they have gone to that para 6 and 5 and 6.
What happens is, your admission register will be sufficient for getting the grant.
No, it is there.
Object is, why the object? It is costing. It is costing. Education is not that free. Which Tagore said, where the knowledge is free. It's not that free. It's an ideal, Tagore's ideal. Therefore, state gives that money to you. That money should be utilized for the students only, not for on the basis of admission register, on the basis of the students that are sent to the examination hall. Otherwise, you will not take care of the students at all. Admission is over. I am getting the grant, whether they
because there is a sort of time, I will take my lord to the section 7D of the Act. There is a provision, my lord. Only in one line I can say, just before rising, my lord, I am just taking. That says, for to get grant in it, the result of the institution should not be less than 50% of the total result of the board. It is not required 30 stand. It is section 3. 11.3 says you must have 30 students in your roll, admission roll. But for granting it says that your results should be more than the half of the result of the board examination. When suppose the board examination result is 90%, is 70%, average board of the state. My result should be half of the above. Suppose 70% result of this year will be more than 35%. So that is the requirement of law. I will take my lord.
So that will take care of the point which I have raised.
Yes. But I will have answer to that one. That is there on the because there is a time limit.
The interim is there, man.
Wherever interim order is there, continue. And the call after 4 weeks. Interim order extend, call after 4 weeks. Wherever interim order, 25 matter 2 weeks, 3 weeks, 24 matters 2 weeks, and the older matters 1 week. But first we will dispose of the older, giving importance only to the new matters. What will happen to the persons in the queue? That's right. Why your old matters are not being posted? Ask them to post old matters, not new matters. Otherwise, they will be in the queue and other new matters we are disposing of.
Your Lordship, items of the permanent PC to the school student matter, Your Lordship.
67.
Your Lordship can accommodate it under precedent. There has been some consensus. Your Lordship, the school has contacted the parents.
70. You are for respondent.
Petitioner, Your Lordship.
I am for the respondent.
If Your Lordship accommodate it.
I have taken instruction that we have withdrawn the letter issued to transfer certificate. That letter we have already withdrawn, but the petitioner not given the undertaking. We have issued letter to file an undertaking before the principal saying not to do such works.
Yes.
Some quarrel was there.
All right. Now, if you give undertaking, that's will dispose of the matter. If they are saying that the order is issued, withdrawn, punishment order, investigation order that was sent out from the school. That order is withdrawn. Therefore, he will continue in the school.
Yes.
Subject to giving an undertaking for the good behavior.
Yes, ma'am.
That's the requirement.
Yes, ma'am.
Take out that.
Item 17.
17. The petition gets under. First stop. Next paragraph. The learned panel counsel appearing for the school submits that the impugned order has been withdrawn and therefore petitioner, only one petitioner can continue, has been withdrawn by the collector's order dated 13 to 25. Which order?
May I just assist your Lordship? I'm actually having the instruction to have of the JNV. On 13/2/2025, the collector passed the order for their compulsory TC. That order was revoked on 6/8/2025, and accordingly we have issued a notice withdrawing the order of and admitting the student. Yes, student subject to the parents giving an undertaking. The parents is not.
Let them give undertaking.
But that's exactly what we are requesting. The parents should give undertaking and they are not giving.
The panel counsel appearing for the school and the authorities submit that the impugned order having been withdrawn, it is open to the petitioners to continue, students to continue to prosecute their studies in the school, provided their parents give a good behavior undertaking within 2 weeks.
Yes, ma'am.
First up, with this proposal, counsel for the petitioner on instructions is agreeable. First up. Next paragraph. In view of the above, petition is disposed of.
My appearance, my name is there.
Need to be written, right? This is your question.